of AEGCL, my lords.
Of
My lords,
whose?
AEGCL, Assam Electric Generation Grid Corporation, my lords.
There's a stay order.
There's a stay order in operation, my lords, and there's a time-bound project, my lord.
But don't you think that you need to mention it before?
My lord, there's a
the
notice.
bench
There's a
floor?
notice to mention, my lords, bench for matters. This for this court, my lords.
Bench. You want to do it today?
My lords, not
You want
today,
to-
not today, my lords. Any date next week, my lords.
Any date to, then you have to mention it before the other judge tomorrow.
Other bench.
Better
matters.
off.
May I please, Your
If
Lordship?
you want to do it today, I'll take it up today.
Today, not my lords. Only.
With regards to item number 2, my lord, in response to the notice today, I'm appearing for this matter. I'm for respondent number 7, my lord. On 21st, we have filed a wakalat number as well as affidavit in operation. And just now I have received a affidavit in operation from respondent number 5, my lord. So,
We'll see when the matter reaches.
my lord.
May I please, Your Lordship? I beg to mention a IA, Your Lordship, for continuation of delay to prefer a restoration petition, Your Lordship. That was the main petition is pertains to subsidy matters, Your Lordship. That is dismissed, Your Lordship, for default, Your Lordship. So my name has not been reflected in the cause list because of that. That is dismissed, Your Lordship. That may be listed on Monday or Tuesday, Your Lordship, as per the.
Mention it tomorrow before the regular bench. What is the urgency today?
Because
There's no urgency today.
not for today, Your Lordship, not for today.
Then nothing. Next.
Please, Your Lordship. In item number 12, Your Lordship, as per the order dated 17/6/2026, Your Lordship has granted us the liberty to make a mention to upgrade the matters.
What is the matter about?
Your Lordship, this matter relates to siphoning of the amount from the person's
Oh, the
account.
old person,
Yes, Your
about
Lordship.
65 years.
Yes, Your Lordship.
My lord, I'm for the respondent bank. The allegation of the petitioner is
no.
that there were some fraudulent withdrawals from his ATM card. On investigation, my lord, we found that the transactions took place in the ATM branch of a different bank, not in our bank. And there was a POS transaction, my lord. Now, my lord, without insinuating anything against the petitioner, it's a submission that for a physical withdrawal from an ATM card, the essential ingredient is a PIN number. So here in this case, the petitioner might have inadvertently given it to someone or he might have been duped of it. We are not aware of it, my lord. Now the petitioner had filed an FIR before the police. Upon our filing of the affidavit in opposition, this court had directed the police to give a report as to what investigation they had done. If your lordship allows me, I'd just like to read out the report that the police had given in this matter.
Look it when the matter is taken up.
My lord?
We will take it up when the matter,
have to look
we will look
okay.
into it at the
Yes, ma'am.
time when the matter is taken up.
Obliged, I thought your lordship wanted to hear my side.
Wait, please. Look, respondent number 7 has served a copy of an affidavit yesterday, my lords. That is the purported first wife.
You are the first wife.
For the first time, my lord.
You have a claim?
My lord?
You have a claim?
Yes, my lord, since I am the first wife, my lord, of my husband, my lord. And as per my lord, pension rule 140.
You have filed an affidavit?
Yes, I have filed an affidavit, my lord. So
We
it
do
has
think
not
we'll
been
have
tagged.
it on some other day. In the
Yes,
meantime,
ma'am.
you get your reply if you have any.
Lodge.
My
With,
lord, and the respondent number 4 has also filed an affidavit. That copy has not been served to me. No, respondent number 4 has
5.
also 4.
You are the mother? I'm the mother. You have filed an affidavit. Sort it
Then
out
they
amongst
served upon-
yourselves. This
Hello?
court is not likely. Normally, it is the rule. Whenever an affidavit has been filed, it is also to be given to the co-counsels. Means for the co-defendant respondents.
I'm ready.
You have to give it to her. He has no problem with that. She has a problem with you. Isn't it, madam?
You're for respondent of 5. 5 has given, my lord, but 4 has not given, my lord.
You are for 7.
I'm for 7.
Four
Who
is
is
the,
for 4?
four is the commandant, my lord.
Commandant, my lord.
Commandant, the employer, my lord.
Commandant who is appearing? Commandant, the
Force.
state commandant?
Yes. Ford's affidavit was filed earlier, my lord, when she was not a party. That is the reason. for
Then
that.
ask that officer or get hold of him. He must be having it.
Oh,
You see,
lord.
madam, it is your internal disputes.
My lord, my lord.
This court don't involve this court. You
I
have
will-
filed
I'll
your
get a copy
affidavit out
from
there.
them.
If you are not in a position to argue, there are many other councils who will be doing it without those affidavits to take it up on yourself. This is not the court out here.
My lord.
Anyways, taking into account that you have filed an affidavit today, we granted a liberty to the petitioner for filing a reply there against. Ms. So-and-so appears on behalf of the respondent number 7
No.
and have also submitted that an affidavit has also been filed. The said affidavit, however, is not a part of the record. The registry shall do the needful. Mr. A. Ganguly, the learned counsel appearing on behalf of the petitioner, submits that he requires some time to go through the said affidavit and if necessary to file a reply. Taking into account the above, list this matter again on 11th of August. You can do it by 11th of
Lodge,
August,
lodge.
11th of August, 2026.
Oblast, my lord.
The affidavit be, if any affidavit in reply is to be filed, the same be filed by 10th of August.
May it please your lordship.
Mm.
Lordship, as per the last order, they were supposed to file the affidavit on 26 June 2026. They filed it on 16th of July. Accordingly, I have also filed my affidavit in reply yesterday. So my lord may fix it for admission hearing. It's not, my affidavit in reply is not on record.
It has been submitted that the respondent number 2, 3, and 5 has filed the affidavit in opposition only on 4/16/7/2026. The petitioner have also filed a reply there against. Considering the above, list this matter on 28/2026. Admission.
May it please the lordship. Last occasion, my colleague had addressed the matter.
Mr. Bonik, unless and until you had challenged that order, what have problem arose out here? Yes, I admit or agree to it that the learned division bench have committed a mistake. But the fact remains that the mistake binds you. Because you are a party to the said proceedings. And if it binds you, this court cannot now ask them to look. The learned division bench ought to have asked them to look into in the parameters of seniority and merit.
Lordship,
The learned division bench did not do so.
DPC, review
No,
DPC.
the learned division bench went into the question of make a comparative assessment on merits.
If I may address on that point, I thought over it. Actually, my colleague had also told me that this difficulty arose. In a case of seniority and merit, the parameters are known. If the parameters are known, the comparison will come on the touchstone of benchmark. There are two ways to look into it. One, lordship says correctly, perhaps, that if this is the direction taken, then it binds you. Then you cannot have a way out. And the other way is, if the rule is there grading on the record, and the rule says,
Understood. That is why.
absolutely on that.
No, Mr.
Lordship, permit me
Mr.
for a
Bonik,
moment.
that is why I was all along with your junior counsel out there. But the problem arises because I cannot pass an order in view of the division bench judgment,
If
wherein categorically mentions that look into the comparative merit between
Correct.
so and so and so and so. And apart from that, the another biggest difficulty which has been put is don't disturb the respond number 4. This is the
True.
biggest difficulty.
so,
Now, if I interfere, ask you to be put in the place of so and so, there will be an amount to be paid by the state for two persons who are not otherwise entitled to.
This, if I read that order, that what fell out, perhaps Lordship is also correct, but let me read out myself if I'm addressing the court. Page 27. The last paragraph.
Yes. Page 28.
I will read from 27.
No,
Or 28.
In the instant case.
Yes. In the instant case, as noticed, the reason put forth was also that the ACRs of the appellant for the year 2009 to 13 had certain adverse entries. In that view, the comparative assessment of the same along with the ACRs of respondent number 4 herein is a matter which has to be taken note by the DPC by excluding the punishment order dated 25/7/2007, and on such comparative analysis, keeping in view the rule providing for promotion, a fresh consideration is required to be made insofar as the case of the appellant is concerned. May I pause for a moment? I put it to myself. If I apply the rule and what appears to be the intent of the language put by the Honorable Division Bench, it would mean whether the minimum benchmark has been attained by comparison of the ACRs. Because if my friend would put forward that this is what the minimum benchmark is by the rule, in that context, this would go. Then it would be wrong. I cannot say that it would be wrong. It would not fit to the place. But if there is no benchmark there, then apply your prudence. It could mean that way.
Now, the problem lies there. Both you as well as the particular respondent have already retired. Retired?
Correct.
And on the date on which the order was passed by the division bench.
My lordships.
So therefore, how the assessment will be carried out? There cannot be an interview.
No, carrying out of assessment, the reporting authority, the reviewing authority, the accepting authority, it is only a case of 90 days. So 90 days is gone because they have it on record. The years are fixed. It is not ongoing process. It's a concluded process. We're viewing it that way, if I may permit it.
No, the problem lies there, Mr. Bonik. You have to understand that although it says about the rule,
My lord.
but the manner in which the rule is to be applied is again comparative, which could not have been.
Could not have been if there would have been a prescribed benchmark by the rule.
Understood. So therefore, it could not have been, the direction could not have been by the learned division bench that you make a comparative assessment of the ACRs.
Here it comes seniority again.
Absolutely. Therefore, I'm saying here, the order which has been passed by the learned division bench here, in that view of the matter, the comparative assessment of the same along with the ACRs of so and so, herein is the matter which has to be taken note of by the DBC. Meaning thereby, the court goes into the question of you only look into the comparative assessment of the ACRs till now. Okay.
It could be.
Then by excluding the punishment, so you don't take note of the punishment order which have been there, but only look into the comparative assessment of the ACRs. Okay, till
Only
now.
touchstone.
On such comparative, keeping in view the rule.
My lord.
So the rule has been mainly providing for punishment, meaning thereby that it is seniority cum merit. Okay, so therefore, and then it further says, don't touch the respondent number 4.
I would address on that also, if lordship
Now
permits
the
me.
problem lies, she would be entitled to consequential benefits and so.
That's a notional benefit. my
In
lord.
such a way, disturbing here in any event would not arise.
If I am Pramila and he's respondent number 4 and I have retired, just have a look at the ACRs in the manner and method the promotion was effected in the touchstone of promotion as seniority cum merit. If there was a minimum benchmark, good. If there is nothing, go to the comparative assessment, see if they meet your requirement as per you. If we could challenge that afresh. If yes, Pramila is to be given the promotion, but she was not given wrongly, the notional financial benefits to follow post-retirement and the pension would be affected by that. That's all. No further, my lord, as I take it. I would appreciate any view what she falls under, but bow down to that. But the way I take it, my lord, it would be that. A concluded exercise can be reviewed on the parameters of the yardstick taken. An ongoing exercise can be reviewed on the parameters of the yardstick to be applied in the process. Here, the accepting, reviewing, and those authorities would not come in. So therefore, those factors are closed chapter. Now, if they do not have the minimum assessment, the minimum merit which is required, then in a concluded exercise, the way we apply the retroactive rules, you
No,
have to take
tell me, how can there be a minimum benchmark?
that hits in the root of the matter.
No, the problem lies there. You are asking, you are already having a foregone conclusion at the time of issuance of the directions
My-
that you only look into the comparative assessment of the ACRs.
Lordship.
Okay. Now, the ACRs, the moment you are asking them and asking them to apply, you are now saying that without a minimum benchmark, it is the seniority who has to prevail.
But why can I get a minimum benchmark?
No, if you don't have a minimum benchmark, if they don't have a minimum benchmark, you see, normally what happens in a seniority come merit, the senior gets it. And when the senior is equal, the merit.
My
That's
lordship.
it. Now, admittedly here, your client is senior. So, if you don't bring in the minimum benchmark, then obviously the seniority will get it. There's no quarrel with that proposition. If we read it in that line, meaning thereby your client has to get it because they have not fixed the minimum benchmark.
Lordship. Lordship.
But the problem lies out there that they have only asked the comparative assessments to be made on the basis of the ACRs.
Leave it to your lordship. Because insofar as I would be addressing.
There could not have been a comparative assessment made. I'm saying,
Yes, correct.
you see, there cannot be a comparative assessment made unless you bring in the question of merit. The merit does not come into the picture. The merit will only come into the picture unless there is a minimum benchmark.
Correct. I get it. So
The
I'm with
problem lies there. The minimum benchmark has to be set. So therefore, the problem is here the comparative assessment could not have been the direction passed by the learned division bench. It should have said that, okay, when you are looking into the ACRs out there, whatever may be, you are looking into art, apply the rule and do it. But the moment you are saying about a comparison to be made with the respondent number 4, you are heading it with the merit of the petitioner with the respondent number 4 on merits. The moment the merit happens, then you could not have, unless there is a minimum benchmark. And if there is no minimum benchmark,
I'm with
then
you.
the seniority seals.
I'm with your lordship. But however, on a different reading of it, that comparative assessment would lead to another conclusion whether he or she meets the minimum benchmark. Only the two.
No,
I got
understood.
differences. Nothing
Understood. No, therefore, my basic, what I am trying to convey to
Yes.
you is, in a seniority cum merit, which has been the traditional rule or traditional meaning of that is the seniority sales. When seniority is equal, then you have the minimum merit. So therefore, the comparative assessment can only be carried out if there is equality in seniority.
Right.
Okay.
Right.
Now, the Supreme Court thereupon have evolved on the question of that there has to be a minimum benchmark when you are being promoted. So this is an evolution by the Supreme Court to the original doctrine of seniority cum merit, thereby saying that for the administration of justice, administration or efficiency, you have to set out a minimum benchmark.
Lordship.
You may or may not. The moment the minimum benchmark is set out, then you cross the minimum benchmark, then the seniority prevails. Okay?
Absolutely.
This is now the concept of seniority cum merit. Now, the moment the minimum benchmark is not there cannot be a comparison. We again have to go back to the traditional doctrine of seniority cum merit. So how do you ask the DPC to look into it?
If I take the impugn order, the resolution passed.
Resolution.
Accepting,
No,
accepting-
Mr. Bonik, I tell you what your junior must have told you. The resolution is wrong.
Oh.
Resolution is wrong, but how do you take care of this particular thing without embarrassing the division bench?
If lordship interferes with the resolution per se on the face of it, we'll take steps to have appropriate applications filed to carve out a way. That can be done. But if lordship interferes with the resolutions and no more, and expresses the mind how the things proceed, on that we can have applications filed for review or otherwise, or clarificatory applications as can be filed.
No, therefore I have to hold that the DPC is wrong.
No, should-
DPC is wrong. Now to hold the DPC is wrong. Now we are concerned that you are retired in 2015. He has also retired in 2015-16, whatever may be.
Not yet.
Now, would it be fair on the part of this court, taking into account the administration, the concept of administration of justice, that after 10 years, this court again sends it back to the authorities concerned instead of deciding that it is wrong?
Might not be decided, quietus to it. What should then,
Why this has to be given?
quietus?
Otherwise, people will lose the faith in the
And I
judiciary.
understand. That another angle would also come in me. If
Now,
lordship-
my question is, how do I deal with
But one
the
thing
direction of comparative assessment?
I understand, but another thing would also need to be addressed from both us, that in absence of a benchmark, was the original promotion vitiated? If so, it merits consideration. by the
You
division
cannot
bench.
touch that in view of this direction. In such a
That's
way,
the
disturbing
promotion.
area in any event would not arise.
Got it.
I can't touch
I
that.
understand.
So the question out here is, the moment the comparative assessment is to be directed to be done, there was a requirement of having a minimum benchmark. When there is a direction for making a comparative assessment, there is a requirement of having a minimum benchmark.
But my understanding is that the moment there is a direction for comparative assessment,
No,
the seniority
problem
cum merit
is
rule
keeping it
vanishes.
with the
my lord.
rule providing for promotion. That is also there.
I understand.
Meaning thereby the criteria of seniority cum merit still holds. But without, my question is, if you don't have the minimum benchmark, then the traditional doctrine of seniority cum merit comes in, where the senior gets it, senior becomes equal, then merit look into it. Which is otherwise the case of merit cum seniority. Merit is equal, then you look into the seniority.
Lord,
But
traditional
the evolution of the seniority cum doctrine is subsequently on the basis of that for the efficiency of the administration, there is a requirement of having a minimum benchmark. So you cannot promote anybody merely because he's a senior. So therefore, it is now being evolved to that effect that the senior minimum benchmark you have it, once he crosses, the senior holds it.
Yes, my lord. That is the seniority cum merit as of now.
No. Understood.
I'm sorry.
This is how it is being done. But the moment you are not fixing the minimum benchmark, my question is, you are required to have it. But the moment you are not fixing the minimum benchmark, then the seniority prevails. There's no quarrel with that. Then you immediately go to the traditional doctrine.
Only seniority.
That is it. And
Only
seniority
seniority.
being equal, then merit comes in.
Seniority cannot be, someone has to be senior or junior.
Understood. There might be. Therefore, when the seniority is there,
Only seniority.
only seniority will hold it.
Only seniority will hold it. But what
Then
I have,
it will become a
apart
case
from-
of seniority.
it becomes a case of only seniority. Apart from, my lord, whatever is there in the brief, my lord, my understanding of the particular paragraph of the Honorable Division Bench is that, my lord, the moment the Honorable Division Bench says that you do comparative analysis of the ACRs or merit, my lord, the seniority cum merit principle, my lord, vanishes, my lord.
Understood.
That's the thing.
Understood. So therefore,
and the
so
respondents,
therefore, when the division bench along with that also say, keeping in view the rule.
true.
The moment the rule is also being implied, means seniority cum merit.
So therefore, without going for a minimum benchmark, your DPC is wrong. That you need
No,
this much.
DPC has done whatever has been said by the Honorable Division Bench. You do comparative analysis, they have got
But
hold of
keeping
the
in view
ACR.
the rule. Keeping in view the rule.
That's true.
So
That's
that
true.
has not been done.
Even if the rule is viewed, even if the rule is taken into account and they does the comparative analysis, then again the principle vanishes. Assuming they have taken into account the rule, benchmark is there, and they have done the comparative analysis, then also, my lord,
No, then for the purpose of initiation, you have to have the minimum, he has to pass the minimum benchmark.
what the says.
Unless you bring in that judgment which you say, which I don't agree, Devdutt, which you say it does not mention.
It's for communication of ACR.
No, communication of ACS is different. But you say it on that day that average a person, he cannot get promoted. You say so.
Normally, my lord.
Normally don't go. If it is a strict proposition of law laid down by the Supreme Court, I will hold it. Don't go on the question of discretion.
Because average is adverse.
Discretion does not have a field out here in view of the directions.
Because average is considered to be adverse, my lord. My lord, what the Honorable Division Bench should have said, perhaps, my lord, subject to, with all due respect, my lord.
Now what do you want? Can this court say that what the division bench should have said?
That's true. That's true, my lord.
What can at the most be said is that applying the rule, keeping in view the rule, I'll just take that part, that keeping in view the rule and applying the directions of the division, honorable division bench, the resolution is bad in law, and the seniority being there, the promotion ought to have been effected today. That's all. They fail on the benchmark part, so therefore the seniority comes in. Once the seniority comes in, I go through. Keeping in view the rule, I take a cue from that, apply the directions, and then the proposition. That's all.
Now, would then this court be entering into the shoes of the selection of DPC, taking into account
Yes.
the minimum benchmark not being set?
That surfaces only in this writ petition. That was never a case earlier, that they don't have the benchmark. Since they don't have the benchmark now.
No.
My lord, there is
The-
another
the
aspect.
benchmark has to be looked into. The minimum benchmark has to be set prior to the
Exercise.
exercise being carried out. The exercise was directed by the division bench to be carried out.
Not sure.
So therefore,
So at that
obviously it would not have been in the earlier round of litigation.
At the point of time when the honorable division was directed for comparison of the ACRs, at that point of time, it was nobody's case that there is no benchmark.
It was not necessary at
Correct.
that point
So
of
now
time.
when we come into that stage,
Because
when
you were more agreed with the adversary entries not being
and
communicated.
we accepted it, we did not challenge that, and it goes.
Understood.
Correct.
But you were concerned
yes.
with the adverse entries,
That's
and the learned division bench categorically say that don't look into these adverse entries.
No.
So far as the punishment part is
Punishment not to
part
be looked into.
not to be looked into.
Adverse entries remain.
The entries would remain. To the extent they are adverse, would be a question of benchmark.
The punishment order will be taken out.
Because that's Penzi sports.
Because the
cumulative-
previous,
non-cumulative
previous,
effect.
the earlier DPC, my lord, took into consideration two aspects. First, the remarks in the ACR. Second, the punishment. So the Honorable Division Bench has said, you keep away the punishment thing and do a review exercise. But the core of the issue is the moment there is comparative analysis, my lord, with all due respect.
So, or in other words, if it is the principle is seniority come merit, there has to be a minimum benchmark.
As of now, that is the law. There has to be a
No,
minimum.
there has to be a minimum benchmark. And if the minimum benchmark is not set, the entire DPC would go. Because then it is taking into the criteria
No.
as a senior. No, Wait, wait,
And see
wait.
that, I understood your lordship's query. my lord.
The moment they don't fix the minimum benchmark, then it will be a case of pure seniority. You see,
Only
we have various
seniority.
principles. One is seniority. One is seniority cum merit.
and
One
merit
is
cum-
merit cum seniority.
Correct,
One
Lord.
is seniority with due regard to merit. One
Yes.
is merit with due regard to seniority. These
Correct.
are all various
And suitability.
criteria, of which the moment the seniority comes in, seniority is merely purely senior.
Purely seniority.
The moment seniority cum merit is where you have a minimum benchmark.
Yes.
That is why the merit concept is there.
Yes, yes.
The moment if you don't have the minimum benchmark, then the DPC is evolving a principle, a criteria which is foreign to the rules. So we can interfere with that and direct the DPC to look into it in terms with the seniority cum merit within 2 months.
Then the division bench order.
That is
subject
the
to-
what I think the
I
division
understood.
bench is not embarrassed then.
Then
The,
page 18.
the division bench direction for comparative analysis, that remains.
So
That
then
remains,
at that
my
point of time, you have to fix the minimum benchmark. And then, because the criterion
Lord,
is seniority cum merit,
But my understanding is that whether there is minimum benchmark or not, if there is comparative analysis of the ACRs, my lord, then the seniority cum merit principle goes.
understood. So that, no, but the fact is you make a comparative assessment or we can very well, this court can very well say the moment the comparative assessment has been directed to be looked into is only for the purpose of setting out the minimum benchmark. And if it is the minimum benchmark, then the seniority will prevail.
I could
I
add
think
on
that
to
is
the
comparative analysis for
Only for looking into the minimum benchmark.
that part was also done in the honorable single judge's case when we had first argument.
No, so Mr. Banik, we are already in a problem in view of two judges. Don't again make the third judge an a party to this.
But they said I am fit. They said in the statement. That's what I'm saying.
Now, I think this is the
That correct me,
win-win situation for both.
Lordship.
a review DPC.
Review DPC, because the moment the division bench says the comparative assessment means comparative assessment for the purpose of qualifying the minimum benchmark,
Lordship.
so that the rule of seniority cum merit could be applied.
Fine, that
And
can
that
be done.
has not been done, and for which the review this is DPC is wrong.
Let them fix a minimum benchmark and consider whether on the basis of her ACR, since lordship can also observe, since respondent number 4.
I cannot observe more
No, what I'm saying.
than what is already given. I'm only here to look into the review DPC.
True, my lord.
The review DPC did not look into that aspect. Any looking
That can be done,
What's
my
the
lord.
order?
That can be done.
heard Mr. Esbonik, the learned senior counsel, appearing on behalf of the assisted by so and so appearing on behalf of the petitioner. Yes, who is appearing for the state of Assam? What is your submission? Nowadays, I don't record the names of the state unless they make submission. They are never heard unless they don't make the submission. Mic is there. Use the mic properly. High Court has not made any submission. What is the High Court submission? Tell me, repeat that, that is enough. What is the High Court submission? From yesterday, 3 o'clock, I've changed my attitude towards the government councils. If government councils has to argue the matter, then their names are recorded. Otherwise, none appears for the government. So make the submission what you have to make.
At this stage, Lordship, I have no submission here. In this. At this stage, Lordship, it is difficult for me to submit. After 10 minutes, I will submit, Lordship.
You are here, you are sitting out here. You know the facts. Are you aware of the facts or not?
Just this moment, I'm appearing.
Mr. Kumusami,
Lordship.
on 16/7, when the matter was taken up, your name was recorded out here, who appeared on behalf of the government. And now you say that you don't know.
Yes,
And therefore, as the matter could not, after 45 minutes, I got the matter adjourned to hear Mr. Esbonik. You were very much present. Then okay. Heard Mr. So the learned senior counsel appearing on behalf of the petitioner. So assisted Mr. H.K. Das, the learned senior counsel, as well as the standing counsel of the Gauhati High Court, assisted by appears on behalf of the respondent number 2 and 3. None appears on behalf of the respondent number 4. As regards the respondent number 1, no submissions have been put forward. The instant petition filed by the petitioner being aggrieved by the which is the resolution? 97.
32. Yes, well, 97.
Being aggrieved by the resolution dated 9/7/2020, by which the petitioners, by which the Review Departmental Promotion Committee, bracket DPC, resolved that the petitioner is not entitled for promotion to the post of supervisory assistant, for which the petitioner was not, and as such, the question of granting the petitioner consequential financial benefit did not arise. Next. The brief facts which led to the filing of the present petition that the petitioner herein was appointed to the post of lower division assistant in the establishment of Judicial Magistrate Morigaon on 1/8/1977. The petitioner was promoted to the post of upper division assistant on 4/12/1992. And since then, the petitioner was working in the said capacity till her superannuation on 31/5/2015. Next. 31/11/2013, the respondent number 3 issued an advertisement inviting application from amongst the upper division assistants having at least 10 years of service, including supervisory assistants, and the appropriate pay grade for filling up the vacant post of head assistant under the establishment of the respondent number 3. Petitioner along with one Sri Konok Chandra Soikia were the only applicants for the post of the promotion to the post of head assistant. Post. However, Sri Konok Chandra Soikia was selected and promoted to the post of head assistant of the establishment. Resultantly, the petitioner being aggrieved filed a writ petition before this court, which was registered and numbered as WPC number 3852/2014. During the pendency of the said writ petition, the post of head assistant again fell vacant in view of the retirement of Sri Konok Chandra Soikia, for which There was no advertisement. Well, vacant on this first.
At this stage, the fourth respondent was promoted to the post of supervisory assistant and allowed to hold the post of head assistant on in-charge basis.
That after Kanak Chandra Soikia,
Yes.
respondent number 4 was made supervisory assistant, the feeder post.
Feeder post.
Then he was allowed the
Hold-
charge of head
Head
assistant.
assistant. Then
Then WPC was filed by the petitioner challenging that
Promotion to the
promotion to supervisory
supervisory
assistant.
then-
25 to 2015
Got it.
order.
and that was put to challenge. This, then
That's-
the litigation.
this came-
That was dismissed, then read appeal, then
Head to hold to-
The post of
supervisor
Sri
is
Kanak
there.
Chandra Soikia fell vacant on account of his retirement. The facts that this, a further perusal of the petition reveals that the respondent number 4 there was promoted to the post of supervisory assistant, which was lying vacant. And thereafter, by an order dated 27/2/2015, the respondent number 4 was allowed to hold the charge of head assistant. The promotion of the respondent number 4 to the post of supervisory assistant by the order dated 25/2/2015 was put to challenge by the petitioner in WPC number 1721/2015. The said order of promotion of the respondent number 4 to the post of supervisory assistant was interfered. Yeah, the said petition being WPC number 1721/2015 was however dismissed by a judgment and order dated 21/7/2017. And the promotion of the respondent number 4 to the post of supervisory assistant was upheld. Being aggrieved, the petitioner preferred a writ appeal, which was registered and numbered as WA 15/2018. It is relevant to take note of that the petitioner superannuated in the year 2015.
15.
On 31/5/2015, and the respondent number 4 superannuated on
that date, my lord, it's not.
Thirty-one, 2013.
31. Huh?
23.
No,
No, can't be.
Huh?
It is chartered full year.
When did he superannuate?
It would be 31/1/23.
2013 lekha hai pura.
भूल निकाला सर मीटर।
Because
Birth is 3/1/63.
Huh?
The birth is 3/1/63.
1 second.
23. It will be 23. It will be 31/1/2023. 3.
23.
23.
It is relevant to take note of that the petitioner
ठीक है.
superannuated on so and so. The writ appeal was thereupon disposed of by the learned division bench of this court by an order dated 27/2/2019. The relevant portion of the judgment of the learned division bench is reproduced here in under page 27, last paragraph of Tiketa's prohibition 2, in terms of which the law stands modified. Pustak. Next. Pursuant thereto, the review DPC was held, whereby the resolution date, impugned resolution dated 9/7/2020 was adopted, thereby rejecting the claim of the petitioner. Pustak. It is under such circumstances the present writ petition filed. The record reveals that on 18/5/2022, when was the notice issued? The
17/9 perhaps.
record reveals that on 17/9/2020, the learned coordinate bench of this court had issued notice the respondents, the official respondents, have not filed their affidavit in opposition. Respondent number 4, though being affected service, have chosen not to appear. In the backdrop of the above, this court have taken up the present writ petition for disposal. Mr. S. Bonig, the learned senior counsel appearing on behalf of the petitioner, submitted that the learned division bench, by the order dated 27/2/2019 in writ appeal number so and so, so directed that there should be a comparative assessment of the ACRs for the years 2009 to 2013 between the petitioner and the respondent number 4. But this comparison was to be carried out within the purview of the rules, which will be Rule 6(2) of the Assam Chief Judicial Magistrate Establishment Ministerial Service Rules 1987. Which provides the criteria for promotion to be seniority cum merit. The senior counsel for the petitioner submitted, drawing reference to the impugned resolution dated 9/7/2020, that the review DPC, while conducting the exercise in terms with the directions passed by the learned division bench in the order dated 27/2/2019, completely overlooked the criteria for promotion, which was seniority cum merit, and purely on the basis of merit held that the petitioner was not entitled to have been to be promoted to the post of supervisory assistant and get the financial benefits He therefore submitted that the impugned resolution dated so and so is required to be interfered with, and as and a direction be issued to the respondents number 2 and 3 to redo the exercise in terms with the directions passed by the learned division bench in the order dated so and so. Per contra, Mr. H.K. Das, the learned senior counsel, appearing on behalf of the respondent number 2 and 3, submitted that there is no fault in the impugned resolution, inasmuch as there was a direction by the learned division bench to carry out a comparative comparison between the ACRs of the ACRs for the years 2009 to 2013 between the petitioner and the respondent number 4, and on the basis thereof finding that the petitioner had one average, 3 good and 1 very good, whereas the respondent number 4 had three very good and 2 goods, have decided that the petitioner was not entitled to have been promoted to the post of supervisory assistant for the purpose assistant, and therefore not entitled to the consequential financial benefits. Learned senior counsel, appearing on behalf of the respondent number 2 and 3, further submitted that the moment the learned division bench have directed that there is a requirement of a comparative assessment, that the review DPC was left with no other discretion other than to carry out the review DPC on the basis of the comparison on the comparative analysis of the ACRs of the petitioner for the years 2009 to 2013 with the ACRs of the respondent number 4. He therefore submitted that in the instant case, no interference is required. Chief Judicial Magistrate rules. This court had duly heard the learned counsels appearing on behalf of the parties. Also perused the contents of the writ petition, and more particularly the directions so passed by the learned division bench, which have been already quoted here in above, and the impugned DPC resolution dated 9/7/2020. The dispute in the instant proceedings pertains to as to whether the petitioner ought to have been promoted to the post of supervisory assistant, or for that matter, whether the promotion of the respondent number 4 to the post of supervisory assistant, ignoring the case of the petitioner, was in accordance with law. It may be relevant to take note of that the learned division bench, while passing the order dated so and so, made it clear that the promotion of the respondent number 4 to the post of supervisory assistant need not be disturbed. It is within the parameters laid down by the learned division bench in the order dated so and so. This court is required to consider as to whether the petitioner ought to have been promoted to the post of supervisory assistant based upon the ACRs 2009 to 2013 and entitled to the financial benefits. Rule 6 of the Assam Chief Judicial Magistrates Establishment Ministerial Rules, Service Rules 1987, for short, the Rules of 1987, stipulates the mode of recruitment. For the post of supervisory assistant, Rule 6.2 Rule 6.2, as well as the note appended thereto, being relevant, is reproduced hereinunder. Perusal of এখানে এইটো দিব, হ্যাঁ, supervisory assistant. From the perusal of the above quoted rule, so it would transpire that a criterion for selection of an upper division assistant to the post of supervisory assistant is required is to be made on the basis of seniority cum merit.
If minority is on a judgment, there's 7 judgment.
I also have.
That's
Concept of seniority cum merit as has been held by the Supreme Court, as was the concept of seniority cum merit is that a senior who has the minimum requisite merit shall be entitled to promotion even though there might be others who are more meritorious. At paragraph number 38 of the judgment of the Supreme Court in the case of State of Kerala versus N.V. Thomas, reported in 1976, 2 SCC 310, the Supreme Court explained the concept of seniority cum merit taking into account the said aspect. Taking into account the relevance, comma, the said paragraph is reproduced herein under. In the case of B.V. Sivaya versus K. Adanki Babu, reported in 1998, 6 SCC 720, the Supreme Court explained the difference between the principles of merit cum seniority vis-a-vis the principle of seniority cum merit. The said aspect is necessary, taking into account for the purpose of understanding the purport of the directions so passed by the learned division bench in the order dated so and so. In the said judgment, the Supreme Court observed that the criterion of seniority cum merit postulates that given the minimum necessary merit requisite for efficiency of the administration, the senior, even though less meritorious, shall have priority and a comparative assessment of merit is not required to be made. It was further emphasized by the Supreme Court in the said judgment that for assessing the minimum necessary merit, the competent authority can lay down the minimum standards that is required and also prescribe the mode of assessment of the merit of the employee who is eligible for consideration for promotion. Such assessment can be made by assigning marks on the basis of the appraisal of performance on the date of the service record and the interview and prescribing the minimum marks which entitle a person to be promoted on the basis of seniority cum merit. The Supreme Court in the said judgment further explained the scope of the criterion merit cum seniority by opining that the said criterion merit cum seniority postulates the requirement of making a comparative assessment of merit, whereas no such comparative assessment is required when the criterion for promotion is based on the principle of seniority cum merit. this judgment, in the case of B.K. Savaya versus K. Adrani Babu, in the case of B.K. Savaya, Supra, was relied upon by a recent was relied upon in a recent judgment of the Supreme Court. In the case of Ravi Kumar Dhansuklal Maheta and another versus the High Court of Gujarat and others, reported in 2024 SCC Online SC 972. Paragraph 87 of the said judgment of Ravi Kumar Dhansuklal Maheta Supra is reproduced here in under. In the backdrop of the above quoted paragraph, the question arises as to how this court would have to read and this court has to understand the purport of the directions so passed by the learned division bench. Inasmuch as there is, on one hand, there is a direction passed that there should be a comparative assessment of the ACRs for the years 2009 to 2013 of the petitioner as well as the respondent number 4. And on the other hand, there is also a direction that the same assessment be carried out within the purview of Rule 6.2. Taking into account the settled principles of law and that the learned division bench was aware of the proposition of law laid down by in B.K. Savaya Supra, and more particularly to paragraph number 87 herein above. It is the opinion of this court that the learned division bench, while directing the comparative assessment of the ACRs between the petitioner and the respondent number 4, had directed that this comparative assessment of ACRs was only required for the purpose of analyzing as to whether the petitioner herein had the minimum standard that was required for efficiency of the administration to be promoted. If any other interpretation is given to the directions passed by the learned division bench, the same would go foul to the settled principles of law laid down by the Supreme Court in the case of B.V. Savaya Supra. Little embarrassment. In the backdrop of the above, if this court now takes note of the affidavit, the impugned resolution dated 9/7/2020, it would be seen that the review DPC decided made the comparative assessment on the basis of the ACRs of the petitioner with the respondent number 4 by applying the criteria
akin to merit cum seniority, thereby not fixing the minimum benchmark. Under such circumstances, it is therefore the opinion of this court that the respondent number, that the review DPC, while making the analysis, while conducting the review DPC, failed to take into consideration the direction so passed by the learned division bench in the order dated 27/9/2000 so and so in the proper perspective, as well as Rule 6(2), which was also the direction passed by the learned division bench to the review DPC to be looked into. Considering the above, it is therefore the opinion of this court that the impugned resolution dated so and so is required to be interfered with. Accordingly, the writ petition stands disposed of with the following observations and directions. The review DPC shall again carry out a consideration, carry out the respondent authorities, more particularly the respondent number 2 and 3, are directed to carry out a review DPC. Now, first to Lekibo, the impugned resolution dated 9/7/2020 of the review DPC is set aside and quashed. Number 2. Respondent number 2 and 3 are directed to carry out a fresh exercise by conducting a review DPC in terms with the directions passed by the learned division bench in the order dated 27/2/2019 in the writ appeal number 15/2018. Taking into account that the review DPC have misconstrued the directions so passed by the learned division bench, this court, for the sake of clarification, this court clarifies that the comparative assessment of the ACRs for the year 2009 to 2013 between the petitioner and the respondent number 4 should be only used for the purpose of ascertaining the minimum necessary merit requisite for efficiency of the administration. First, once if the petitioner, who admittedly is much senior to the respondent number 4, crosses the minimum necessary merit, minimum benchmark, comma, the petitioner has to be granted a notional promotion for the purpose of enjoying the financial benefits, financial pensionary benefits, financial benefits only limited to pensionary benefits in accordance with law.
This court further, for the sake of clarity, observes that though the petition, that in the circumstance, the review DPC considers that the petitioner ought to have been promoted and grants the notional promotion, the same shall be done, the same if done would not affect the rights of the respondent number 4, which is already saved by the learned division bench in the order dated so and so.
Lord, only one factual correction, my lord. At the beginning of the order, my lord, while dictating lordship recorded the remarks in the ACR, three good and one average. My lord, in fact, the resolution at page 32, they have recorded it wrongly. In fact, there was 3 average, 1 good, my lord.
I can't say that. I have only mentioned they said. I never said
No,
anything.
no, no, it's a
I'm not going to. You have not filed affidavit. You have not produced the records.
page
Make
20,
that. Should I record it?
page 21, single judge's order, it's there, my lord.
I'm not going to.
So fine, my lord, fine.
Which should we trust?
Otherwise, DPC,
Should we trust the single judge who had noted it from some other document,
records.
which the single judge had not looked into it? Or should I look into the officers out here who have looked into it?
He only wanted, my lord.
End of the exercise would be an observation from their stand that that the other respondent was 4 was found to be more fit.
That cannot be. I have therefore said only for the purpose of minimum bench. I'm not on that.
Only for that.
I can't help it.
My lord, this particular information are required for preparing the cabinet memorandum. For preparing the cabinet memorandum, for placing the rule, my lord. Just a formality, my lord. It's not that, my lord. New action will be taken to prepare the final stage, my lord, to prepare the cabinet memorandum. These justifications are required, my lord, as a procedure. So sooner it is provided, my lord, they will prepare the memorandum.
It has already been forwarded to the rule committee. I have instruction, my lord. It has already been forwarded to the rule committee, my lord. Immediately we will send it after the.
Now, my question is, yeah,
We find.
you see, the thing is like this.
My lord.
At one stage, when the draft rules were made, which the legislative department had on the objection, was on the ground that you have put an introduction.
Yes.
Preamble.
The legislative department says that these are there, which will be there, and we duly take note of it. But it should not be a part of the rule.
It was mentioned Renu and all in the.
The LR, who has also occupies the position of the secretary of the government of Assam Judicial Department, is essentially a what do you call, a grade 1 officer of the government of the district judicial, of that, what do you call, the Assam Judicial Service. He has been appointed only for the purpose to be a conduit between the judiciary and the executive. The tenor of his letter, not what should have been. He should have he knew it. He knows it. He could have very well said that for the purpose of doing it, it was required, so kindly if do it. It's a different thing. But to again ask something, as we say it in Assamese, that in Ramayana, after the Ramayana, somebody asked what happened to Hita, who was Hita? Something like that. I think the LR, or for the purpose of that, the secretary of the judicial department should have been more conscious about this aspect, rather than writing a letter with that tenor, which is not expected of him. There's a difference between an officer who is holding the post of in the government. Yes, the commissioner and secretary, all these things, they are absolutely, they have nothing to do with the judiciary.
they may, for the purpose, the finance department may finance many things. These are different aspects which has touches on the judiciary. But for the purpose of an LR, that is why he is known as the LR. So he has to be more careful about this thing. Mr. B. Gogoi, the learned additional advocate general, submits that the communication which was issued by the Secretary, Judicial Department of the Government of Assam was only for the purpose of inserting, only for the purpose of putting inputs in the cabinet memorandum so that the draft rules which have been prepared can be placed before the cabinet for finalization. Mr. H.K. Das, the learned senior counsel, as well as the standing counsel of the Gauhati High Court, further submits that the said aspect have now been placed before the rulemaking committee of the Gauhati High Court in the administrative side for doing the needful. Considering the above, list this matter on 10th of September 2026 for an update.
In this case, matter we have received our instruction, Lordship. We would like to file our affidavit.
Huh?
We have received
Matter
instruction.
change to
Petitioner is a SAS agent, Lordship, postal agent. He was not allowed to continue his job by the postal authority, despite there being a specific order from the licensing authority, and nothing is found in an investigation also by police also against him, but they are not allowing.
what is an SAS agent?
It is, Lordship, standard savings, standardized agency system.
So what is your right to be an agent?
This is a postal agent, basically postal agent, to introduce these account holders, open account. So I get a commission from
You
this.
require permission.
Yes, there is a license. License has to be issued by the Deputy Commissioner's office.
So do you have a right over the license?
No, my license is valid. My license is valid till December 2026. So
What they
postal,
have done, they are not allowing you to do what?
postal authority, Lordship. Postal authority wrote to the licensing authority to terminate my license. I came before this honorable court. I have been given an liberty to file a representation before the licensing authority. Thereafter, a speaking order was passed saying that the contention of the postal authority is not correct because there is nothing is found against me by the police also. So there is a direction to allow me to continue my job, and my license is also still valid. It is till December 2026. It is valid, but even then they are not allowing me. That's why I am before this court, because it is my only source of income.
And what does the postal authority say?
There is an order, please honorable court, on 4/5/2026.
Yes, the affidavit has been filed.
Yes, filed.
We have to file our affidavit, Lordship.
Why haven't you filed your affidavit?
Lordship, last occasion, we are directed to file affidavit. We have received instruction.
Last to last, not last. Last was on 15/6. Last to last.
Yes,
Why haven't you
in the
filed
May-
your
in the month of May?
Why haven't you filed your? Next Friday, next Thursday. Your affidavit.
Lordship.
Let's ask this person to come. The
Lordship.
senior planning officer, Kamrup Amingao, and commissioner of police to be present in the court.
Lordship, I will file.
The petitioner's grievance is that though the petitioner has a license which is valid up till December 2026, the respondent in the postal department is not permitting the petitioner to carry out his functions as an SAS agent. The record reveals that the senior postmaster had issued two communications dated 17/10/2024 and 13/3/2025 to the senior planning officer Kamrup Amingao as well as the commissioner of police to take certain actions against the petitioner. Understood. I know that. I read that. That is why I passed that on. It is under such circumstances this court sought for instructions from the senior planning officer Kamrup Amingao as well as the commissioner of police to be brought on record by filing an affidavit as far back as on 4/5/2026. And there was a specific direction for filing of the said on or before 15/6/2026. However, no affidavit was filed on 15/6/2026. And as on date also, such affidavit have not been placed on record. Mr. S.D. Purkaister, the learned counsel appearing on behalf of the petitioner, submits that on account of the delay caused by the said respondents, the petitioner is suffering as his sole source of livelihood is being affected. Considering the above, this court fixes this matter again on 6th of August 2026. It is observed that if the affidavit as directed by the order dated 14/5/2026 is not filed by the senior planning officer Kamrup Amingao as well as the commissioner of police, this court shall be constrained to seek the personal appearance of these officers on the next date. Inasmuch as, on account of the delay caused by them, this court is not in a position, it is affecting the administration of justice. What is this? Your mining has been cancelled.
Yes, Your Lordship. Now they have withdrawn our notice that we may be now, even after withdrawal of their notice, we are not allowing to do the mining business.
Which notice?
We have filed an additional affidavit.
13/2/2025. Where is that 13/2/2025?
Yes, Your Lordship.
Where?
At page 92.
You are which one?
Uh, Number 3, Your Lordship.
Cancelled.
Yeah, yes, Your Lordship. Now they have again withdrawn that notice.
Where?
You have filed an additional affidavit.
Where page?
Page 140.
So what remains in your petition?
We are not allowed to continue our mining business.
So isn't it a separate cause of action? Your case was limited only to that. Who is not allowing you? 2 came because of 13.2.
Yes, sir.
13.2 has, now you are being allowed to go ahead with the mining.
Yes, sir.
Then
My lord, lordship, will look at page 92. The mining, it is in the name of the executive engineer PWT Kohara, not in the name of the petitioner. And the, my lord, environment clearance certificate has already been, my lord, expired, my lord. Without EC, my lord, mining cannot be operated, my lord. Lordship will look into, my lord, the validity of the mining, that is in, my lord,
page 83.
page 56, my lord, repetition. That is the extension of mining. Date is 2/1/2025.
How do you know?
My lord, it is the top of the, my lord, top, dated 2/1/2025.
Then
Then, my lord, page 57, my lord. Last paragraph before the copy 2. Extension of EC is approved for project so and so for 1 year.
subject to laid down by SCC and.
Content console laid about the SCS is SIAC, my lord, and then the area in question is to be reflected in the DSR. So it is, has already been over, my lord. Without EC, my lord, mining operation cannot be allowed to done.
Anyways, Mr. Counsel, your thing has become this.
Yes, sir.
We do one thing. We record his submission that in view of the mining permit, mining, what is this? EC.
Yes.
The environmental clearance having been expired, you are not being permitted. And in the circumstance you get a renewed one, they will permit,
Yes, that,
isn't it?
My lord.
That is the only thing I can
Yes,
give
yes,
it
my
to you.
lord, during this pendency of this writ petition, some of the NOCs already expired, my lord. So in the meanwhile, they already, my lord, revoke my cancellation and allow me to operate. Now, my
But-
lord, dispose of this matter, my lord, directing them to allow me whenever I, my lord, receive my renewal, my lord, of the NOCs.
My lord, it is to be, my lord, verified, my lord, before applying for fresh NEC, EC, my lord, he has to submit all the documents, my lord, and we will consider that only. And it is the EC is in the name of the executive engineer, not in the name of the
Yes.
petitioner. So the executive engineer, PWT Kohara Roadman is required to submit the required documents, that's whether he has requirement or not,
But
my
why
lord.
did you allow Bhaskar Sharma to do it?
My
as
lord,
per
he is
your
the
communication?
third party, he
My
has
lord-
made an agreement with the, my lord, executive to
Kindly come to 140.
1/4. My lord, this is the communication of the divisional forest officer, my lord, to the secretary, my lord, that by virtue of an agreement with the executive engineer, he is, my lord, obtaining the, my lord, stones, and he has a crusher unit and he has crushed stones. my lord.
Understood. Now you see, at the time of cancellation, it was done against the executive engineer.
And my lord,
It is done.
my lord. EC is in
Now,
the name of the
You
executive engineer, not
cancelled it.
my lord.
Now, the same you are permitting him in his name.
My lord, it cannot be, my lord, if the EC is
So
not.
isn't it the document by
My
issue?
lord, yes, my lord. I cannot submit it, but the,
You can
how the
do this.
divisional officer write this, my lord, if the EC is in the name of the executive engineer, the permission is in the name of the executive engineer, petitioner is the third party, my lord. And without an EC, my lord, at this stage, my submission is that without EC, my lord, mining operation cannot be carried out. And there is a direction from the Central Empowered Committee.
Kindly come to
also.
page 51. Oh, this comes under 5.1. Assam minor municipal.
minor.
Yes, it is under 5.1.
Well, I have the asset-
Therefore, the thing
Yes,
is like
that-
this. You have given it to the executive engineer, he has given it to the contractor.
Yes,
So the
contractor.
contractor has to be given.
My lord.
Yes. Now the contractor has been given and therefore you find this page 51.
51, my lord.
So therefore, the thing
And that is also, my lord,
that
over, my lord.
he knows, he will help it in doing it through them.
My
Yes.
lord,
My
You
lord,
submit it.
my lord.
You
my lord.
consider it.
And that is also over, my lord. It is of 2022. It is, it was for 36 months. Page 51 also, my lord. Dated 29/4/2022. It is for only 36 months.
And my lord, subsequently already, my lord, page 52 is extended, my lord. Page 52.
For
Extension of my agreement, my lord, with the PWD.
April 2026.
extended till when?
April
lord.
2026.
26, my lord.
April.
Where do I get it? April 2026
Last
is
paragraph.
also
Before
over.
the last paragraph.
April 2026 is also over.
Over, my lord.
Now thereafter,
My lord, already we have submitted application, my lord.
but
lord,
you are
please.
appearing for you are appearing for respond number 14. You have filed the affidavit
My
on
lord.
behalf of the respond
My
number
lord, my
14
lord, 14 I will pay.
with the divisional forest
Forest
officer
officer.
Karbi Anglong.
My lord.
You can't go against what he has done out here at page 140.
But it is in contradiction of the, my lord, EC, my lord.
Tell
of
me,
EC.
you can't say anything to that effect.
But my lord, as I am appearing on behalf of the KAC also, my lord, so I am pointing out that EC is not now valid. I am appearing for the executive engineer also, my lord.
And interestingly,
My
this
lord.
document do not mention anything.
My lord. But if you
In the
lordship,
page 140, do
But
not
if you-
mention anything
but-
as regards the executive engineer.
but if you lordship look into page 141, letter of the secretary, my lord,
Uh,
it has been last line, my lord. The operation of the stone quarries and a stone crusher would be allowed after obtaining all the mandatory statutory
It's okay,
clearance.
that is okay.
So after without
No, no,
clearance, my lord, it
but-
cannot be allowed.
But my question is,
My lord, I'm getting it.
why the
I'm getting it, my lord. I'm getting it, but I have no answer.
executive engineer is
But-
nowhere in the picture?
My lord, executive engineer also wrote that it can be operated, my lord. But the
No,
next
kindly
142,
No, kindly come to page 92.
my lord. My lord, it is in the name of the executive engineer, EC.
Understood? Then you see authorized agent Sharma,
My lord,
meaning thereby he is the person concerned.
my lord, person, he is authorized by
So
the
therefore,
executive engineer.
your department also recognizes him
My lord, as my lord, agent of.
as authorized.
My lord, my lord.
But
My lord,
it
that
is
is correct.
surprising that
Yeah,
page
factually that is correct.
140 and 141
My lord.
do not make a reference to the executive engineer PWD Quora.
My lord, first, my lord, if a petitioner has not annexed the, my lord, EC, my lord, environment clearance, first environment clearance. In the environment clearance was issued in the name of the executive engineer. It appears from the, my lord, page 92 that environment, it means that the environment clearance obtained by the executive engineer, not by the petitioner. So the, for extension of the environment clearance or for the fresh environment clearance, the for renewal that executive engineer is required to take steps, my lord.
No, there's no quarrel with that. I'm not on that.
My lord.
My question is, why there is no reference at page 140 and 141 to the executive engineer? My question is that
Well, my lord.
while cancelling it, you put the name of executive engineer to
My
the
lord.
authorized
My
agent.
lord.
But why there is no reference to at page 140 and 141 to the executive engineer? It should have been mentioned that so and so
My lord.
authorized so
It
and
should
so.
go to the, my lord.
Well, that is
My-
one. Or
my-
is it a fresh one?
My lord.
Is it a fresh one?
My lord.
Because once you have cancelled it,
Mm.
unless you revoke the cancellation,
Yes,
is
my
it a
lord.
fresh one? My
My-
question is
yes,
that.
my lord, my lord. I got that, my lord. I have, my lord.
Yes, Mr. Forrest, what do you say? Yes. Because one is a cancellation. Once it is cancelled, unless you revoke the cancellation,
My lord.
it is a different thing.
My lord.
So therefore, my question is now, is the divisional forest officer directly giving it to him?
I got it.
That is an instruction which needs to be taken that are you giving directly to, because what he is asking is not on the basis of a contract with them.
My lord.
If it was done under Rule 5.1,
My lord.
what happens? The government runs him as contract
My lord.
or mining. Look here, you carry out the mining and use it for this particular contract. This is how it is being done.
Mm.
Now his contract ends on April 2026.
26, my lord.
So therefore, the government is out.
My lord out.
You have cancelled you have cancelled it for
Yes.
him.
My lord.
Unless you revoke the cancellation,
My lord.
which is to be done only by the, because the cancellation is done by the Secretary Department of Environment.
My lord.
If the cancellation is done by the Secretary Department of Environment, can the divisional forest officer grant him anything? My
Well-
question is that.
My lord. But
It
anyway,
doesn't look like a simple matter.
my lord. My lord. Anyway, my lord, without, my lord,
Understood, but Mr.
Hello.
Sethi, at the moment
Hello.
I say so,
my lord.
what you are saying that, okay, allowing him to do
No,
it.
I'm not allowing.
No, allowing subject to submission of all these documents
Mm.
by the executive engineer, you are saying. But are you saying that it has been revoked, the cancellation? Where is the revocation of the cancellation? Just 140, it doesn't say about revocation of the cancellation. It appears to be a fresh contract and he is into, he has a
He has
stone
to,
crusher.
he has to enter a fresh contract. He has to obtain the, my lord, then only he can only.
No, then, are you, once you have cancelled it,
My lord.
unless you don't revoke it, then can you do so granting him a contract by the DFO without tender? Unless it is through the government.
My lord. If your lordship thinks I can take the telephonic instruction whether
Isn't
that
it,
has been
Mr.
revoked.
Because section 11, if I'm not wrong, section 10 or 11 of the mine regulations,
mineral
that is regulation,
My lord.
and also your mining contract, minor mineral says to give a contract to anybody, there has to be by way of a tender. Okay. Now, if it is now being given individual to him without a reference to this, would this be permissible? This is a very serious thing. Can this court overlook that?
My lord.
You get the point,
My
Mr.
lord,
Counsel?
my lord, my lord.
It looks very innocuous. But the fact remains that once you have cancelled it, that too by the secretary,
My lord.
and now can the divisional officer allow him to go ahead
My lord.
without
No.
a tender?
Cannot, cannot, my lord. Cannot.
Government cases, government can give.
Government is different, but it is not. Therefore, I'm asking you, why at page 140 and 141, there's no reference to this person?
Examiner, my
It
lord.
seems that the divisional forest officer concerned have committed something wrong. I record it in my order and get your instructions on this.
My lord, I have sought the
My lord,
instruction.
but
on
my
that.
LOI is my
I
LOI is
sought the
still valid, my
instruction,
lord.
but long back, my lord, I have not received the instruction.
No, you will get it now when I
My
put
lord,
it.
this earlier contract LOI, my lord, which is granted to the PWD in the name of PWD, it is still valid up to December 2026.
No, Mr. Counsel, you have to understand this.
My lord.
When a contract is cancelled, the cancellation has to be revoked. The contract has been cancelled qua the executive engineer. Okay? Now the executive engineer in this, you are now being permitted to go ahead and carry out extracting the minerals and all. Now, if you are now being allowed to go ahead, would it amount to revocation of the earlier one? And if it is not a revocation to the earlier one, isn't it amounts to a fresh contract? And can a fresh contract be granted to you without a tender? That is the question.
My communication is there on 22/5/2026.
Otherwise, we won't allow it.
My lord, my lord, my lord.
He has challenged the year.
My lord.
So you have challenged it on the ground that this is being challenged by to the executive engineer,
Mm.
PWD.
My lord.
And the executive engineer, PWD, is not before this court. So therefore, how do you get the year unless you have been given the power of attorney on his behalf? How is your reputation maintainable? Isn't it, Mr. Gogoi? This reputation ought to have been filed by the PWD.
So the first read petition was
my lord,
withdrawn on that ground, my lord. In the first read petition, the petitioner filed this petition, executive engineer was also not made a party. So that read petition was withdrawn, that is the subsequent read petition was filed.
But now you appear on behalf of the executive engineer, PWD also.
My lord. Yes, my lord.
You appear.
No, my lord, my contract,
Now, if you are appearing for the, what is your instruction?
My lord, if lordship may look my communication, I have not received the instruction, my lord. Regarding, my lord, this divisional forest officer letter, executive engineer letter, all these queries, my lord, I sought the, my lord, instruction on that, my lord. How this, my lord, additional affidavits on the basis of additional affidavit. But it is on the direction of the CEC. Other cases, lordship has already fixed a series of cases. Senior Advocate P.K. Goswami argues. All this, my lord. This is also, my lord, initially, my lord, this also, my lord, on the basis of the government of Assam's direction, CEC's direction. So, my lord, it was cancelled, my lord. But subsequently, only in this particular case, it was revoked. All other cases, it was not revoked. It is revoked only in this particular case, my lord.
Now I know how to get their information. Don't worry.
My lord, my lord.
I'll put it in such a manner
My
that
lord.
if they don't, the petition would not proceed.
My lord.
But Mr. Counsel, how are you maintaining this reputation?
my lord, I am a contractor, my lord,
So
in
what?
this case, my lord, and my contract has been granted after, my lord, tender.
No, understood. Everything is understood. You have been given the contract for mining only as per 5.1.
Yes,
Okay. Meaning thereby, they have given you a captive mine for the purpose of extraction of the minor minerals.
yes.
This is given under Rule 5.1. Now, if they don't give it, you purchase it from outside and claim it.
No, my lord, my only question by prayer is, my lord, now LOI is granted in the favor of the PWD. Now PWD through tender, my lord, given the work to me. Accordingly, my lord, I have set up all this, my lord, the requirement and, my lord, running the my lord, query, my lord, on the by submitting by paying the revenue. Now, as per my LOI, my lord, I have to pay only the royalty and the taxes, not the KISS money. Now they have cancelled my this permit, my lord, on the ground that I have not submitted KISS money. But KISS money and security money is not required to according to this LOI, my lord. This is a permit holder, my lord. I have to pay the royalty. I am paying. So, my lord, this order is illegal. That's why I have challenged.
No,
before
have
this
they said, as the forest department of the Karbi Anglong say, that you only have to pay the KISS money, the royalty?
No, LOI, my lord. LOI,
No, no.
Can the PWD say that? It
Yes.
is a dispute between you and the PWD then.
No, my lord, order is passed by them, my lord, saying,
They cannot pass that order. You see, the materials do not belong to the PWD.
Well-
The materials belongs to the what you call the forest,
yes, my lord,
isn't it, Mr. Gogoi? Yes. It belongs to you.
yes.
If you are selling it, you you sell it to the heir by taking royalty. You have a mine. A mine, either you give it under 5, subject to payment of the materials as well as the royalty. If you give it that particular mine to a lessee, the leaseholder, you will earn. Because you are giving him a contract that for this particular period, this much CUM, if you mine, you have to pay me this, apart from that royalty. This is your contract. So the payment has to be made. So it is your dispute with the PWD.
No, my lord, we are directly paying to the forest department, my lord, all the royalties, my lord.
You cannot. You have to pay for the kist also.
My lord, as per the LOI, my lord, I have to pay only the royalty.
So that is, therefore, your dispute is with the PWD.
My lord, that's why, my lord, I have
Because
made,
the PWD on their own cannot say that you need not pay.
no,
or
my
the
lord, this
PWD
impugn
has
order
to
is,
pay.
my lord, impugn order is passed by the forest department.
My question is, the PWD either has to pay on their own, or it has to be a part of your contract where you are going to pay and they
Yes.
will reimburse you. Now, but PWD cannot say that the forest will give them free of cost.
No, my lord.
No. So therefore, the forest won't give it because the forest will earn revenue from there.
Well, but my prayer is, my lord, this impugn order is on the ground that CTO city earnest money deposit, security money deposit is defaulted. That's why this has been cancelled.
Understood?
Not that,
So
I am
therefore,
not-
who has not paid?
my lord, by the PWD.
So why PWD is not before this court?
My
Who
lord,
has
that's why,
not-
but my lord, I am the financially loser, my lord, because I am the
No, it
contractor.
cannot be. You do not have anything out there. You do not have anything out there to that effect that you have been only given a license under 5.1. So the license, if it has given, they are not permitting you, you have to take recourse against the PWD.
My lord, in this case, our PWD has been made party. That's why, my lord.
Understood? So PWD, your claim is not against the PWD. PWD has to be a petitioner and challenge this this revocation. And in fact, the manner in which it has been given to you to permit it by DFO goes against the minor mineral rules. So we do one thing. First, on the ground that the executive engineer is there, not only this, we also interfere with page 140 and 141 in view of the violation of this. Or you withdraw.
My lord, let them come. No, this matter.
No, let them come,
No,
forget about them. They are
sorry.
not going to come.
My lord, Friday, my lord. Friday, I will satisfy, my lord, on Friday. My lord,
Satisfied now, on a
My lord,
Thursday.
my only prayer is, my lord, I have, my lord, acquired this contract, my lord, on the basis of tender. Now, my lord, in the rules, my lord, permit holder, my lord, PWD is a permit holder, my lord. Now they cannot operate this mine, so they given to me through in tender. Now my proper tender, my lord, I have,
You have not been granted for a tender. PWD, what is the tender for?
my lord, for this work,
What work?
for this my lord, extracting of this stone, on the basis of this LOI.
Huh?
On the basis of the LOI, my lord, granted by the forest department, my
Let
lord.
us see your work order.
My lord. My lordship, may kindly come to this page 30, my lord. My lord, kindly come this page 30. It is the LOI, my lord. Or up to, my lord, 2026. Then, my lord, this annexure 3 is the, my lord, contract. And my lord,
What do you have to pay then?
my lord, this annexure 1 is the LOI, my lord,
Let us see the LOI.
page 30.
This is for a period between
21-22 to 25-26.
Huh?
The subject, my lord, in the subject column,
issue of letter in LOI
with reference to the appeal provision, so and so, and man under this provisional order is issued, granting of mining permit as per requirement in respect of sand grade and so, which will be it from so and so. On receipt of this provisional letter, we should get 10%. We should also submit additional proof which supports this financial services, environmental impact assessment, so and so. Level royalty in favor of principal secretary, so and so. 2.5 times royalty plus monopoly, so and so. So you have made this payment, the royalty and all?
Yes, my lord. There is no default, my lord. And my lord, kindly come annexure 4. This is the LOA, my lord, granted in my name. Page 51, my lord.
Time for completion is 24 months.
My lord. Then subsequently extended, my lord.
Why?
My lord.
You have not extracted.
No, my lord. In the initial stage, that cannot be, my lord, due to some problem. So that was subsequently again extended.
No. Did you have you expected 1,60,373?
No, my lord, this is time to time, my lord. As per the requirement of the department, I have to submit it, deposit the royalty accordingly on the basis of royalty, my lord. Only that amount of quantity I can extract as per the challan.
So you mean to say that the PWD, which is a contract for 2 years, have been extending
Yes,
on the basis of the extraction?
yes.
How much you have extracted till now?
My lord, that instruction is not there, my lord. Now, as per requirement of the PWD, my lord.
It cannot be.
My lord, kindly see page 51, my lord. In except 4. And my lord, kindly see page 66, my lord, CCA, my lord, consolidated consent and authorization. It is in the name of this petitioner as well as the executive engineer.
The tender was for 2 years.
Mm.
You have been granted an LOI for 3 years. Fantastic. It only happens in the state of Assam or in the state of Telangana? No, you have you issue a letter of intent. LOI. The tender was for 2 years.
My lord. And it is page 32, it is by lord, EC is at that time, my lord, has a service provider is required to obtain
And
the
the issue
EC
to
also.
notice with the proceed with the work is for 3 years. Now, let us see.
Now, page 35, it is for 2 years, time of completion.
No, it's okay. I'll see page 51. The same tender.
Yes, my lord, my lord.
It is for 3 years.
Page 35, it is for 2 years, my
2
lord.
years.
Page 35. Date of commencement, time of completion 24 months from the date of commencement. And he is the service provider for extraction of the materials, my lord. Page 35, agreement form. Whereas the employer is desirous that the service provider for extraction of materials from Pampri, Stone and GSB permit area so and so. Here is called the work and the employer has accorded the EUI by the service provider. Time of completion, my lord, 24 months. Then, my lord, but in the 51, it is for 36 months. Date is, if your lordship look into the dates also. 8/4/2022, first one. Second one is of 29/4/2022.
Now, kindly come to page 52.
the extension.
My lord,
Come to the last part, one paragraph.
my lord,
After
after the
threadbare
threadbare
discussion.
discussion, the committee has decided to extend the agreement period till April 2026, and the additional period shall be renewed every 1 year with the agency for extraction and of PWD stone quarry so and so on demand of the development project, and also the committee.
Meaning you are going to give it to him in perpetuity.
My lord, that is the execute, it is the minutes of the additional souvenir,
How is it possible?
my lord. Without
But it
AC
was for 3 years,
Hmm.
you, in 2024, you take a decision to give it for another 1 year, to another 2 years. Because this is dated 2/4/2024. Another 2 years, and thereupon extend it every 1 year.
my lord. It is a minutes, but it is not acted upon, I think, my lord. It is the minutes of the additional souvenir. The additional souvenir minutes that he wants to, my lord, for extension, but it all, everything is depends upon the receipt of the environment clearance. As the environment clearance is not there, so the question of operating the mining at this stage does not arise at all, my lord.
Understood. My
lord.
question is,
My lord.
how can you grant an extension like this? Means you are going to give it to him in perpetuity.
Next, page 53 is the person, my lord, who was present. Nobody other than the other persons were present. Only, my lord, those persons are present.
Executive engineer, PWD, financial advisor, assistant engineer, executive engineer.
My lord, of PWD only the persons are present. There is no forest person or nothing, my lord, like that way, my lord, or in the council level. It is in the PWD additional chief engineer level, my lord. So for justification, the petitioner, my lord, annexed this document, but whether it has been acted upon or not, my lord. That as it has not been acted upon on that, my lord, and it has already been cancelled, my lord. So the basic agree party is the executive engineer, as his mining permit, as his, my lord, EC was cancelled, my lord.
Is it like Borolen out here also, the DC and the superintendent of police is outside Karbi Anglong? In Borolen, what happens? DC and superintendent of police is outside here.
Also, my lord.
Here
Not-
also.
Yes, here also, my lord. The law and order, my lord, DC and my lord, it is not under the, my lord, council jurisdiction. In all the 6 schedule area, my lord. Only the, my lord, district magistrate only issued the, my lord, when the blasting is required to be done, permission is required to be obtained from the district magistrate.
My lord, I think, my lord, this, since the LOI is granted for, my lord, this 5 years, my lord. So I think PWD, my lord, they are time to time extending this work.
LOI given by 5 years means?
The original LOI, my lord, for the
Ah.
work is page 30. Page 30, my lord.
That period is also over.
No, up to 26, my lord, 25, 26,
April, March,
December, my lord.
31st March.
So that's why, my lord, it's time to time, I think they are extending. Because, my lord, since page 66, my lord,
Mr. Gogoi, what are the amounts which are required to be paid as per section rule 5.1?
Includes everything which is to be given by the regular contract.
How much? What are the things?
One is cubic meter manner is mentioned in schedule manner.
Huh?
In the schedule manner, there is a schedule. What is the rate against particular specific quantity? As certain cubic meter has X, that we pay as Y. And manner
It will be there in the rules.
yes, it is in the schedule manner. And thereafter, when the DMFT lordship
No, here they have put it. They have put it, if you come to page 30, they have put it. Royalty, 1.5 times the royalty, monopoly fee, so and so. What is the payment to be made to the year? Can only payment of royalty be enough? The DMFT is okay. You know, that is ready. Kindly come to page 30 of the report. These are the things which the PWD has to pay.
Lordship will find in the schedule appended to the rules.
It will append it. Yes. Rest. Page,
Rates of royalty.
page.
Page minus my book is, my senior book is page 364.
Page?
364 of this agreement.
Got it. This is rates of royalty.
Rates of royalty.
Now, here the royalty is there.
Well,
Kindly see this, page 30 of
30,
that
yes,
document.
sir.
So except royalty, there is nothing else to be paid.
EMFT and GST is.
That is okay. Do you pay anything for the price of the goods? No.
No.
You only pay royalty.
Right.
So royalty will be rate for royalty in rupees.
Yes.
Rupees 100 per CUM. So this is the royalty which is to be paid.
This is it.
So if this is the royalty to be paid, you will pay this royalty on the basis of the kist.
Well, it is included in the case.
Now tell me one thing, when you allocate the tender, what do you say normally? And as I could see in various tenders, that he quotes a rate. Why do you have a tender? You have a tender for getting the best price
That's right.
on the CUMs.
Right.
You categorically mention how much quantity of CUM per year
Yes.
in your tender.
Right.
Meaning thereby, it cannot be based upon the royalty.
My lords.
It has to be something more than the royalty,
Yes.
because the royalty has to be separate.
It is separate.
So
It's
then,
another component, my lord.
then are you giving to the department free of cost?
No, well, they have to also pay. Department also has to pay.
So department has to pay. Here they have only said about the royalty.
Right.
Is it required for payment of, apart from the royalty, for payment of the price of the goods, of the stone materials? My question is this, because if you see remember, in all tenders of the forest department in respect to mines and minerals and all this thing, you say whoever gives the highest price, meaning thereby it has to be a price based upon having nothing to no relation apart from the royalty, and all these other things has to be paid. So therefore, what is paid apart from that is the price of the materials, which is the subject matter of tender. That somebody says that, okay, 1500 CUM per year, I pay 3 lakhs. Somebody says 3.5 lakhs, you give it to him. So this is the price of that 1500 CUM of materials. Okay. So therefore, for them, apart from that, that is the KISS money. That KISS money will be there, and then you divide it into 4 KISS money. Once you divide it, along with that, the royalty and all this corresponding has to be paid. Now, therefore, my question is, if that be so, what is page 30? Isn't it amounts to giving it free of cost?
It is like it. Yes.
So they will only pay the royalty. So if it is the state purchasing it, you are giving it for free. No, it appears from this. Because if you see this particular document, which I can get it, I'll see page 39 of the document. So this is the basis on which the tender has been floated. So therefore, the PWD would be taking the air from the Karbi Anglong Autonomous Council to directly procure it. So this will be done in terms with 5.1. So the 5.1 will also include the price of the materials. So by why this is not there at page 30? Is your divisional forest officer losing on that amount, or is it given for free if it is the PWD? There has to be a resolution to the effect.
And application for mining property in management is notified of the agency universal. I don't know that one.
And Mr. Counsel, are you paying the royalty? And all other DMFT and all these things you are paying. So therefore, his case is, then look here, I have been paying the royalty which is given here. Where is the kiss money for? And if you see page 92, it is dependent on the amount which has been paid. So this page 30 appears to be, if page 30 is the proper document, then 92 is a wrong exercise of power. Huh?
Page 92.
Yes.
Names the permit holder as the PW.
Huh.
So any cancellation is perhaps due to non-submission of those requisite amounts whatsoever, by the PW. Not by the patient.
Understood. My question is that. So here it says the non-payment of the earnest money deposit, security money deposit, non-clearance of the KISS money amount as per your letter reference so and so. So here it is cancelled. It is not suspended. Once it is being cancelled, this cancellation has to be revoked. Now the cancellation is done by the level of a secretary, Department of Environment. Now can the DFO on its own say that he can permit? This is at page 140 you see. And within that amount too, granting of a contract to him, the horse what is given to the PWD. It doesn't make a reference even to the PWD.
Just a communication that he can open whatever mining area, commence mining operations subject to conditions in that specific area.
Understood. But once the contract has been cancelled, the mining permit, mining lease has been cancelled. That mining lease has been cancelled by an authority which is higher than the DFO. So once it has been cancelled, isn't that to be revoked? And can by an officer who is junior do so without revoking it? Permit him. And if you are permitting him within that amount too, granting a lease separately because you are not even making a reference to the PWD. And if you are not making a reference to the PWD, see the next letter at page 141. Now this is the secretary, which is the subsequent document. This is 6.1 by the divisional forest officer and the other one is 9.1. The 9.1, the person who should have revoked it, he writes a letter subsequently to the divisional forest officer, interestingly. And the divisional forest officer issues the order prior to that on 6.1. Is it ever heard of? Huh?
Every ingredient is put on the same plate, madam. These are separate issues. They are trying to justify this reopening in connection with that earlier contract.
Opening of the stone quarries in Stanway under northwestern so and so, outside the so and so. And it has been given to him. Here also, the executive engineer nowhere in the scene. And Mr. Mr. Suti, I'm surprised to this effect that the person who has to revoke writes a letter on 9/1 and the person who grants the permission to him writes a letter on 6/1.
16-1, 1602,
Where?
142, page,
No, page 140.
or page 140 is 6-1, madam.
Page 140. Writes to the secretary.
My lord.
May open the
May
so
open,
and
madam.
so and so. This is for your kind for information. For me, that the higher authority of Congress and has directed Sri Vasco so and so may be allowed to in the query so and so. It's 140.
Madam.
Then he
But there's
says
a
that
condition,
okay,
madam.
allow him.
There's a condition the outside the entire catchment area of river, so that is the Supreme Court's order.
With regard to the, I have the honor to state that the secretary so and so, by letter number when I mentioned in the reference, have cancelled the so and so, permitted at so and so. Accordingly, the office directed Bhaskar, who was permitted to extract from the mining, to stop here. Now, if Karbi Anglong authority pleases to revoke the cancellation order by letter dated mentioned in the reference number above, then this court has no objection to allow extraction to so and so. Now the things again change. Now the executive engineer says that he may be permitted because the Karbi Anglong Autonomous Council wants to give it. Because you see, you cannot say anything because Karbi Anglong higher authorities have said. Because the higher authority is saying, asking the divisional forest officer, he is acting on it. See, with reference to I have the honor in it that all that the higher authority of Karbi Anglong has directed so and so to and allowed him.
The directed Bhaskar may be allowed to.
Okay, let me think about it. At 2 o'clock, we'll pass an order.
My lord, I'm sorry, my lord. In item number 2, my lord, Mr. Manish, senior advocate, Mr. Manish Singh, was to argue, my lord, for item number 2. But my lord, he is held up in Honorable Supreme Court in some urgent matter. my lord.
Let's
So-
hear, madam.
Yes, plus.
First of all, I'd like to ask you to tell me as to whether this court can frame the points of difference between the two judges and then decide this reference, or is it the duty of the two judges to frame the difference and then the matter could have been referred to me?
Millards, if I may just take your lordship, because this was raised, the first question is exactly that, Millards, because ultimately you have the application of the LPA and then section 98 or the first principles. But broadly, just to give your lordship an idea of this, Millards, I've seen both of them, Millards, the difference is academic. So exercise, whether it is of section 98 CPC or of clause 36 of the LPA, I've gone through the charter, Millards, is effectively the same. One says point of law and one says point. So
Yes.
because that's the only difference. So in any case, facts are not in dispute here. It is only law. So the difference remains academic. Millards, also generally speaking, just for your lordship, Millards, because this was an academic query, the special law has to prevail. LPA should prevail in the normal sequence. Again, I say the difference is academic, but I'm putting it before your lordship. Then, Millards, on the points itself, Millards, there are two judgments of the Honorable Supreme Court, Millards, which deal with this broad issue. So, and I'll also say this, Millards, as far as we are concerned, as far as we as councils are concerned, Millards, we have no difficulty whether, Millards, your lordship deems it fit.
The problem is tomorrow, if it is challenged on the question of the point being not formulated by the two honorable judges,
Yes.
and this court then, yeah, because if you see section 98,
Yes.
it says, provided that where the bench hearing the appeal is composed of two or other even number of judges belonging to a court consisting of more judges than those consisting the bench, and the judges composing the bench differ in the opinion on a point of law, they may state the point of law upon
Yes.
which they differ, and
Yes.
the appeal shall then be heard upon that point only by
Yes.
one or more of the other judges. Such points shall be decided according to the opinion of the majority of the judges who have heard the appeal, including those who have first heard it.
Yes.
So therefore, without formulating that point
Yes.
of difference,
Yes.
can this court decide this aspect? The reference could on by way of an administrative order,
Yes.
the matter can be placed.
Yes. So, Milods, what your lordship is absolutely right, Milods. However, I must bring to your lordship's attention, Milods, in the judgment of State of Andhra Pradesh
Yes.
versus Pratap Karan, the Honorable Supreme Court was in such a case, Milods, formulated the points, found, Milods, that the formulation of points by the third judge was in accordance, Milods.
Yes. Which paragraph? Practice.
Yes, Milods. If your lordship will turn, Milods, straight away to page 100, para 42. And in fact, this objection was taken of section 98, exactly what your lordship is raising. Para 42 at page 100.
Yes.
By urging this additional ground, the learned senior counsel for the appellant submitted that the procedure adopted by the High Court in the disposal of the appeal is not in consonance with the provisions contained in section 98 CPC. Learned counsel submitted that the appeal in the High Court was originally heard by two judges who differed in their opinion and wrote two separate judgments. While giving judgments, both the judgments have not recorded their opinion on the point of difference on the point of law. Without formulating the point of difference, the matter was referred to a third judge by the Chief Justice, and the third judge finally passed the impugned judgment concurring with one of the judge. According to the learned counsel, therefore, the impugned judgment is vitiated in law and cannot be sustained. I'm sorry, I only smile because this is exactly what your lordship said. It could be raised. Then, Manoj, at page 106, 108, at para 56. Coming back to the instant case, para 56. Coming back to the instant case, the two learned judges of the division bench passed separate judgments. One of the learned judges allowed the appeal and set aside the trial court judgment, whereas another learned judge affirmed the trial court finding and dismissed the appeal. Both the learned judges differed not only on the points of fact but also on the point of law. The learned Chief Justice therefore referred the matter to the third judge for deciding the appeal. The learned third judge, after going through the judgment of the learned differing judges, formulated various issues and recorded his finding on all the points. The learned third judge finally upheld the findings recorded by one of the learned differing judges and allowed the appeal. In our considered view, therefore, there has been complete compliance with clause 36 of the letters patent of the Andhra Pradesh High Court, and the appeal judgment cannot be vitiated on that account.
Now, let us see the 36, because there it is referring to 36, but out here,
Yes.
see 36, if you see paragraph 45.
Yes.
Yes. Here it is parameteria.
Yes, please.
It is parameteria to 98.
Yes.
Herein also say, but if the judges should be equally divided, they shall state the point upon which they differ, and the case shall then be heard upon that point by one or more of the other judges, and the point shall be decided according to the opinion of the third majority.
Yes. Your lordship is right. It is identical belows to section 98.
Now then what, if that here the Supreme Court
upheld the fact that the third judge formulated the points which was not so formulated by the split verdict, and then held that that was in order, and the judgment was not vitiated on that account. My Lord Justice Iqbal and Justice Nagappan in this judgment. There is another judgment also, once your lordship is done, I'll point out though of Himachal Pradesh High Court, where it effectively holds the same. that if there are points of differences, then the learned third judge can, my lords, formulate the points, and that would be in accordance with the provisions of law.
Come to paragraph 55,
Yes, my lords.
more particularly paragraph number, where they have quoted paragraph 7 and 8. See
Yes,
paragraph
lord.
Mr. Yogendra Mishra. There it gives some indication to that effect. Appearing for the respondent, plaintiff raised the preliminary objection that since the points were not stated by the bench, the reference to a third judge was illegal. I do not see any merit in this argument inasmuch as the points, although not expressly enumerated by a joint order, are apparent from the judgments. It is nowhere preemptively prescribed that a difference of opinion has to be formulated by a joint order. Besides, the irregularity is not in not doing so, if at all, is a formal nature and does not vitiate the proceedings, including the reference. By
Yes.
examining that is how it has been done. So I
So
think it's paragraph Rulia Devi. It's paragraph number 5. This is by the Patna High Court.
Yes, Mr. Patna High Court.
By the Patna High Court. Okay. So then I can take it up.
Yes, Lord.
Now, madam, what are the points of difference?
Yes, Lord. I have
are-
given, my lords, your lordship some written submissions. If your lordship can kindly refer to it. I have formulated the points, my lords. One, my lords, I have formulated for your lordship's assistance, and then I will take your lordship through the points as formulated by each of the judges, my lords.
Okay. You have
At page,
submitted a written submission?
yes, my lords. Your lordship had desired it, so we thought it would be best to give it.
That was respond numbers 1, 2, and 3.
So, my lords, at page 8,
File B, file B. File B.
at point 8, at page 8.
Yes.
So, because here for the ease of adjudication, as your lordship, what page 8 minutes? Point 8. For the ease of adjudication of this honorable court, the appellant herein has taken the liberty to frame the following points to be adjudicated and settled on grounds of conflicting opinion of the predecessor bench. First reference point, whether the circular dated 6/8/14 is ultra vires and ought to be set aside.
First point is whether the regulation 2.5.1A, this is not yours?
No, Milos, it may not be because I am referring to a document which
Okay.
we are the appellants here, your lordship knows.
The respondent numbers 1, 2, and 3. You are the respondent or the plaintiff?
We are the appellants, Milos.
Appellants. So will be another one.
And I'll take your lordship to the points as framed by the judges also, Milos.
Yes. You have given it here. Okay. A, production, then. Yes, what are the points in your written?
Yes, Milos. So at page para 8 or clause 8, Milos, for the ease of adjudication, the appellant has taken the liberty to frame the following points to be adjudicated and settled on grounds of conflicting opinion of the predecessor bench. So the first reference point, Milos, is whether the circular dated 6/8/14 is ultra vires and ought to be set aside.
Okay. Okay. Point 8.
Yes.
Yes. First point reference, whether
Yes.
the circular is ultra vires and ought to be set aside. Okay.
Even though, Milos, in all fairness, I must tell your lordships, the learned single judge has upheld the circular. It was assailed, but no finding or reasoning given. And therefore, my lords, the logical corollary that it was upheld. And it has also been upheld in yet another proceeding, my lords. I'll come to that later. But right now, this is an issue because one of the judges, the judges had considered it. I was just mentioning that factor. They shouldn't have. We were in appeal. We are in appeal, not the other side. So therefore, the finding it become final, he shouldn't have. That's my first submission. We will be on that point subsequently. But nonetheless, as a referral point, because your lordship is looking at points now. Second reference point, which is the main one, in fact, whether the notification dated 4/7/2020 passed by the state through the Chief Secretary banning commercial import and trading of dogs and dog markets and commercial sale of dog meat in markets and dine-in restaurants is valid in law. This is, of course, one of the critical issue. The learned single judge had found that there was no authority to do so. Both the judges have found on it. I'll show that also for reference and convenience. The third reference point is whether the impugned notification dated 4/7/2020 is violative of the fundamental rights of the respondents numbers 1 to 3. The 19(1)G is pleaded. They are traders without valid licenses. That's another story. I'll come to that on merits.
Okay.
Anyway, it's a health and security issue. It's not business.
And they have also given another point of reference.
As I'm afraid,
The written submission of the respondent numbers 1, 2, and 3.
I don't think we've got those minutes, but as a matter of fact, we tried our best to give your lordships the points. So therefore, I'll just show your lordships.
They have mentioned 3.
That's right, because I don't know which 3 they are.
2.5.1a of the food safety and this FSSA regulation is merely definitional standard setting, or whether it prohibits slaughter of every animal not enumerated therein.
Because I'll show your lordships what the judges considered, because what your lordships will be required subject to correction of the points of formulation would be the points that have been considered by the learned judges. They formulated it. I've only taken it from there.
Okay.
So we don't need to go, we cannot go beyond that, with due respect. So may I point out, where the learned judges, have formulated their own points and the discussion there too.
Okay.
I am
The
taking
third ground which they have mentioned, the point of difference appears to be same with number 2.
I see.
Which you have given at 8.2.
Yes, because I have no objection to what they've given to the extent that they can give, but the requirement of law on a split verdict is the points that were considered by the learned judges and where there's a conflict.
Okay.
Those are the points of formulation which your lordship is required to look into. And formulate the same, of course, for consideration. So we don't want to amplify further, but anyways, I'll just point out and I'll leave it to your lordship after that. So, in my written submissions itself, your lordship can take it for convenience. At page 3, at page 3, the issues framed by Honorable Justice Budi Habung, who held against us, the first issue, second issue, third issue, fourth issue.
The first issue is not a point of reference.
Because ours actually covers this in all entirety instead of framing it as a, yes.
The respondent counsels say that this is one of the point of difference.
Because firstly, ours is
slaughter of animals not enumerated therein.
Actually, if your lordship takes it, for a moment, just let me go through the issues. I'll come back to this. Your lordship is right. The second and third may be similar, so in any case, there's no ambiguity on that. But as far as the issues framed by Honorable Justice Abung is concerned, these are the 4 issues. And if your lordship will just come down to number 5 in my written submissions, we put out what Honorable Justice Robin Phokin had framed as issues.
Okay.
And the issues as framed by us, proposed issues, as suggested for your lordship's reference, actually covers broadly all these issues if your lordship sees. I leave it to your lordship.
Yes.
The second issue that we had,
But madam, don't you think that the formulation of these issues
yes,
or the points of difference has to be again traced back to the pleadings, not of your appeal,
yes,
because your appeal is an intra-court appeal.
yes.
Depend upon, because you were not the writ petitioner.
That's right.
So the writ petitioner was the respondent numbers 1, 2, and 3.
Yes.
And if the respondent number 1, 2, and 3 have pleaded, on the basis thereof, there can be the points of issues which have been framed. Because issues will be dependent upon the pleadings.
Well, the pleadings actually are much lesser than what has been considered. The submissions went far beyond that. So to that extent, if your lordship goes to pleadings, it will be even more limited. Even more limited. And we have to ultimately only take whether learned judges disagreed. The original is not important. The pleadings are not. So this, if I may say, the intra-court appeal has to deal with points of difference as per both the provisions of law, LPA and the section 98. So the points of difference have to come through. That is the purpose of the exercise. Two have differed, a third judge takes a view and goes with the majority. That is the basic premise. So in fact, your lordship has to, in a broad way, to take up cudgels one way or the other. I shouldn't use the word cudgels, that's a wrong word. But take the position. Or come to a reasoning, a finding.
Madam, we do one thing.
Yes.
Let me formulate these issues, the points
Yes.
of difference.
Yes.
And then ask you to ask the parties to address on that.
Absolutely. But that must be so.
That is a better option, because
absolutely,
for me to write a judgment after and at the time of judgment to formulate the points of difference, it may prejudice either of the parties.
No, your lordship is absolutely right. We are totally with your lordship. So say, please formulate the questions of law, the points of law, and proceed further, and we'll address them, and then your lordship will take a view on that.
Now, relying upon these two judgments, which
Yes.
one is your judgment of a state of Andhra Pradesh, as well
Yes.
as the other
Yes.
judgment which has been passed by the Patna High Court. On that basis, I take the jurisdiction for formulating the points of difference.
Yes.
And then
Yeah.
formulate the difference. I think that would be better off, so that
Absolutely.
on another day, both of you can argue on this point. You have already given your written submissions.
Yes.
We will look into this. And I think that is the better course of events.
Milord, your lordship could also take one more judgment on this, Milord, which is the Himachal Pradesh judgment, Himachal Pradesh High Court. Just for your lordship's notes, is being handed over. Rajiv Bhardwaj versus State of Himachal Pradesh. And exactly this, Milord. At page 26, para 59. And then again, your lordship, has your lordship got that? Page 26, para 59.
Okay.
None of the decisions mentioned above state without prejudice what prejudice would be caused if the third judge also calls out the points. What difference would it actually make if another division bench is constituted and they state the points of difference? Authors of lettered patent did not contemplate the current situation. Moreover, culling out the points of difference is not a Herculean task, but just a ministerial act that even the third judge can also do very comfortably. Lex necessitatis est lex temporis. That is instantis. In a case of extreme necessity, everything is common. The law of necessity is the law of time, that is time present. And accordingly, the judgment proceeds to hold so much.
No, it's okay. So we do one thing.
Yes.
I do one thing. I pass an order today itself.
Yes.
Formulating, I think they have asked for let us put this, the Budi Habung have formulated this point, which is issue number 3.1.1. In your written submission, you have put it 3.1.1, madam.
Yes, my lords.
In your written submission, you have put it
Yes.
3.1.1.
Yes, lords. I have, my lords.
Yeah, so that is what is one of it.
Yes.
One that is there. Then number 2, which is there of yours, is already there.
Yes.
So that is, they also have said so.
Yes.
Third is as regards whether FSSI's letter dated year has statutory force to create or sustenance of such prohibition.
Yes.
And then we put the other, that's 8.2, we put it, and
Yes.
whether so and so is violative of fundamental rights. So let us have it these 5 as the points of issue difference, and then proceed and fix a date for hearing.
Because your lordship can, because very well, just one objection I had was to the circular. The statutory force, because this was not an issue.
They have said that whether the circular,
Yes.
you have also said whether the
I
circular
have, but that is
so-and-so
ultra vires.
and ought to be set aside.
That is ultra vires.
It's okay. They are also saying here that whether so and so has the has statutory force to create or sustain such prohibition.
Very well, lords. Your lordship may frame it, because I don't mind. We'll be
Yeah.
able to meet the points, lords.
Then there is a consensus, broad consensus amongst the parties to we frame it and then fix a date for hearing.
Yes, lords.
Miss, you go by as per this. There's no further points for determination, for points for difference.
Agreed.
And Mr. Iralu, you are there.
I'm here.
Yeah, these are the 5 points which we are going to formulate as the points for difference.
Yes.
Okay. And then on the basis of that, we'll hear it.
Very well.
Okay. Ms. Pinky Anand, the learned senior counsel, assisted by so-and-so, who appears on behalf of the appellant in writ appeal number 7/2023. Mr. J. Gore appears on behalf of the appellant in writ appeal number 12/2024. Mr. L. Iralu, the learned counsel, appears on behalf of the respondent numbers 1, 2, and 3 in writ appeal number 7/2023, who are also the respondents in writ appeal number 12/2024. Two learned judges of this court have passed separate judgments whereby Honorable Mr. Justice Budi Habung dismissed the writ appeals, being writ appeal number 7/2023 and writ appeal number 12/2024, and affirmed the judgment of the learned single judge,
dated 2/6/2023, passed in writ petition number 128 bracket K of 2020. On the other hand, Honorable Mr. Justice Robin Fukan, by a separate dissenting judgment, allowed both the writ appeals and set aside the judgment and order dated 2/6/2023, passed in writ petition number 128 K/2020. While both the learned judges passed separate judgments, the learned judges, however, did not formulate their points of the points where they differed. Be that as it may, in view of the diversions of the opinion, the Honorable Chief Justice of the Gauhati High Court have placed the matter before this court to resolve the divergence in the opinion by an administrative order dated 12/5/2026. Ms. Pinky Anand, the learned senior counsel appearing on behalf of the appellant in writ appeal number 7/2023, drew the attention of this court to the judgment of the Supreme Court in the case of State of Andhra Pradesh versus Pratap Karan and others, reported in 2016 to SCC 82, and submitted that a similar issue arose in the said proceedings before the Supreme Court. And the Supreme Court, at paragraph number 56 of the said judgment, held that there was no infirmity in the learned third judge formulating the points of difference and thereupon upholding one of the judgments delivered by the differing judges. The learned senior counsel also referred to a judgment of the learned Himachal Pradesh, of the High Court of Himachal Pradesh, in the case of Rajiv Bharadwaj versus State of Himachal Pradesh, reported in 2020, SCC Online HP 2105, and specifically referred to paragraph number 59, wherein also the learned third judge who was referred, to whom the reference was made, culled out the points of difference between the two differing judges. This court have duly perused both the judgments, so placed by the learned senior counsel appearing on behalf of the appellant in writ appeal number 7/2023. And more particularly to paragraph number 55 and 56 of the judgment in the case of the state of Andhra Pradesh, Supra. For the sake of convenience, taking into account its relevance, the said paragraph number 55 and 56 in the case of the state of Andhra Pradesh, Supra is reproduced hereunder. In view of the opinion, in view of the opinion of the Supreme Court in this case of the state of Andhra Pradesh, Supra, this court is of the opinion that this court can formulate the points of difference between points of difference, which could be culled out from the two judgments delivered by the two honorable judges of this court. This court have also heard the learned senior counsels appearing on behalf of the appellants, as well as the learned counsel on behalf of the respondent, on the points of reference, on the points of difference. And upon hearing the following points of difference are culled out for adjudicating the present reference. Number one, whether the regulation 2.5.1 bracket A of the food safety and standard bracket food products standards and food additives bracket close regulation 2011 is merely definitional / standard setting, or whether it prohibits slaughter of any animal not enumerated therein, ? Whether the FSSI letter dated 6/8/2014 the Food Safety and Standard Authority of India had acted beyond its delegated powers by issuing the circular dated 6/8/2014. Or in other words, ultravirus, the provisions of the FSSAI Act 2000 regulations. Ultravirus what? Ultravirus, the FSSAI regulations, FSSAI SA Act, Food and Safety, so and so Act 2006, and the regulations framed therein under. Number 3, whether the Chief Secretary, Nagaland, had the authority to issue the notification dated 4/7/2020 banning commercial import, trading of dogs and dog market, as well as sale of dog meat in market and dine-in restaurants. And then we stop it till there only. Whether the fundamental rights of the petitioner, that is the respondent numbers 1, 2, and 3 in the that is of the petitioners, have been affected on the basis of the impugned notification dated 4/7/2020. এটা হল পাঁচটা হল না?
My lords, we may actually add a line whether it'll be saved under Article 19(6), reasonable restrictions. Even if their fundamental rights are affected, if it's a reasonable restriction, it may be saved. So we may frame it in that accordance.
Is it your case in your pleadings?
My lords,
Is it your case in your pleading that it is a safe or not? You can very well argue that.
my lords, it's a legal submission we made before the court and has been considered by the two judges. And a legal submission, my lords, respectfully can be argued at any stage. Respectfully, my lords.
Now, whether a fundamental right has been violated or not is always dependent upon, a right to trade is always dependent on 1916, 1906.
My lords, that's precisely our case. I appear for the appellants, my lords, in case.
Understood.
Yeah.
So
Yes.
therefore, that is very much there.
Yes,
When
my
we
lords.
are, because that is what you have proposed as the issue number, at paragraph number 8.2.
8.3, my lords, correct.
8.3. The
Yes.
fundamental rights of the respondent numbers 1, 2, and 3. That
Yes,
is
my
what
lord.
you have proposed. So I
Yes.
put it only there. Queda al pasta, no? Next. Whether the FSSI letter dated 6/8/2014 has statutory force to create or sustain such prohibition. Question mark. So taking into account that this court have today formulated the points of difference, an opportunity has to be granted to all the parties to address on these points of difference. Accordingly, this court fixes this matter when 10th of September.
Agreeable.
What's obliged? 10 September is, we're obliged.
What?
10 September is fine, your lords. Thank you so much. We'll take it.
On 10th of September 2026 at 2 p.m.
Obliged, my lords.
Okay, Mr. Iralu.
Obliged.
Item 11 to continue.
Heard Mr. K. Sinha, the learned counsel, appearing on behalf of the petitioner. Union. Government of Assam. Mr. S.R. Bolwa appears on behalf of the respondent number 1. Mr. D. Gogoi appears on behalf of the respondent number 3, 4, 5. Huh? 1 and 8. Mr. 20. Mr. Jwanta J. Sutia, the learned senior counsel, as well as the standing counsel of the Karbi Anglong Autonomous Council, appears on behalf of the respondent numbers
7,
7,
12, 11, 12, 13,
7, 11, 12,
13,
13,
14,
14,
15, 17 and 18.
17 and 18. You also appear for 16 also, na? Mr. S. Bolwa appears on behalf of the respondent numbers 9 and 10. None appears on behalf of the PWD Department of the Government of Assam. None appears on behalf of the Union of India as well as the PWD Department of the Government of Assam on call. The petitioner hearing is aggrieved by the letter dated 13/2/2025, whereby the mining lease mining permit which was granted in favor of the executive engineer PWD Kohora Road Division, Dolamara, was cancelled. The present writ petition the brief facts leading to the filing of the instant writ petition are that the Divisional Forest Officer Karbi Anglong East Division Difu, that is the respondent number 14, isn't it? 14. Have issued a mining permit in favor of the Executive Engineer PWD Kohora Road Division on 29/12/2021. For mining of sand gravel to the tune of 128,760 cum and stone materials to the tune of 400,933 cum from the Pranpri Anglong PP land. It was categorically mentioned in the said mining permit that there would be a requirement of payment of the royalty for the stone materials as well as for the allotted stone materials as well as the sand gravel. Further to that, the environment impact assessment from the Environment Impact Assessment Authority. The mining plan has to be approved. The records further revealed that the PWD department so assigned to the Karbi Anglong Autonomous Council, instead of carrying out the mining by themselves, initiated a process for a tender process for extraction of the minor minerals by issuing a notice inviting expression of interest for extracting of minerals dated 8/4/2022. A perusal of the expression of interest, which is a part of the writ petition, reveals that the PWD, under the authority of the Karbi Anglong Autonomous Council,
instead of purchasing the raw materials from outside, had taken an initiative to directly procure forest materials such as stone metals, sand, sand gravel, etc. from the concerned competent authority. And as such, have floated the expression of interest to engage a third party with required infrastructure and experience in the field of handling, mining of minerals and producing ready-to-use product of stone materials. Pursuant to the said notice inviting expression of interest for extraction of minerals, an agreement was the petitioner herein was selected and an agreement was entered into on 29/4/2022. For a period of 24 months from the date of commencement of the said agreement. And the quantity so mentioned in the agreement was 1,60,373 cum of stone that is at the rate of 80,186.50 cum per year, and sand gravel of 51,504 cum for 2 years at the rate of 25,752 cum per year. The record further reveals that though the agreement which have been mentioned the period of granting permission for extraction to be for a period of 2 years. But on the same date, a letter of a letter and the notice to proceed with the work was issued in favor of the petitioners. For the extraction of the quantity so mentioned in the agreement dated 29/4/2022. But the period was enhanced to 3 years. It may not be out of place to mention that the period so mentioned in the notice to proceed with the work appears to be faulty in as much as the calculation which has been mentioned at serial number 3 appears to be actually 2 years. The records further reveal that the mining plan was approved by the Director of Geology and Mining Assam for a period of 3 years. Expiring on
Is 55 is for 2 years.
Hmm?
Is 55, Director of Geology and Mining, it is for 2 years.
for 2 years. Expiring on
Expiry is not mentioned, my lord, but date of order is 17 December 2021,
expiring in the year 2023.
my lord.
It is also seen that subsequent thereto, there was an application submitted for granting an extension of the environmental clearance and this extension was granted on 2/1/2025 for a period of 1 year. That is, the same stood expired during the pendency of the instant writ petition on 1/1/2026. Be it as it may, it is seen that on 13/2/2025, the mining permit which was granted in favor of the executive engineer, PWD, Kohora Road Division, was cancelled by the Secretary Department of Environment, Forest and Forest, Karbi Anglong Autonomous District, on the ground of earnest money, security deposit on the ground of pending in CTO, CTE, earnest money deposit, security money deposit, and non-clearance of KISS money amount. The petitioner who was granted the contract for extension being aggrieved has approached this court by filing the present writ petition. The record reveals that the learned coordinate bench of this court on 28/5/2025 issued notice the respondent number 14 had filed an affidavit in opposition on 7/11/2025. And the petitioner had filed an additional affidavit on 22/5/2026. The additional affidavit
so filed by the petitioner has relevance. Inasmuch as the respondent number 14 had written a letter to the Secretary, Department of Environment and Forest, Karbi Anglong Autonomous Council, that is the authority who had issued the impugned communication dated 13/2/2025. That in view of a decision taken up by the higher authority of the Karbi Anglong Autonomous Council, the petitioner may be allowed to open the stone quarry and stone crushers in the Karbi Anglong East Division, Difu. This communication was issued on 6/1/2026. On 9/1/2026, the Secretary, Department of Environment and Forest, it may not be out of place to mention that the said communication which was issued by the respondent number 14 to the respondent number 15 do not mention or even refer to that a mining permit was only granted to the executive engineer PWD Kohora Road Division, that is the respondent number 18, or even do not endorse a copy of the said letter to the respondent number 18. This court also finds it relevant to mention that on 9/1/2026, the respondent number 15 had written a letter to the respondent number 14, thereby granting approval for the no objection certificate for opening of the stone quarries and stone crusher. In various ranges and further mentioning that the authority of Karbi Anglong Autonomous Council was pleased to approve for the NOC to the petitioner. It is further mentioned that the said approval that the operation of the stone quarries and stone crushers would be allowed after obtaining all mandatory statutory clearance. It is further relevant to mention that there is no mention in the said communication. There is no mention or any reference in the said communication that a mining permit was actually issued in favor of the respondent number 18, nor a copy of the said order was forwarded to the respondent number 18. It is further seen that on 16/2/2026, the respondent number 18 had written a letter to the respondent number 14,
the respondent number 18 has no objection to allow extraction of forest materials from the mining plan by the petitioner. First. This court, in the backdrop of the above, heard the learned counsels appearing on behalf of the parties. Mr. K. Sinha, the learned counsel appearing on behalf of the petitioner, submits that taking into account that the respondent number 15 who had cancelled the mining permit have now permitted the petitioner to carry out the mining operation. The petitioner is willing to carry out the mining operation after procuring the necessary clearances which are required. Mr. J. Chutia, the learned counsel appearing on behalf of the senior counsel who appears on behalf of the respondent, appears on behalf of the Karbi Anglong Autonomous Council, submitted that the petitioner, if if the petitioner wants to carry out the extraction, the same can be done so only after obtaining the necessary permissions. The learned senior counsel further submitted that the environmental clearance which is required had expired on 2/1/2026. Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department of the Government of Assam, submitted that if the petitioner wants to carry out the extraction, the same has to be done within the purview of the Assam Minor Minerals Concession Rules 2013. That is, by obtaining the necessary permissions as required under law. This court, upon hearing the learned counsels for the parties, and this court, upon hearing, this court have heard the learned counsels for appearing on behalf of the parties and have perused the materials on record. From the materials on record, it is seen that the petitioner does not have a mining permit, have not been issued any mining permit. The mining permit have been issued only to the respondent number 18.
Which was expired on 2/1/2026. Earlier lordships.
Which had already expired. No, it has not. It has not.
EC environment clearance, my
No,
lord.
no, mining permit.
Oh, mining permit.
This is a mining permit. Huh? And this is given for period from when to when?
This 22 to 25, 26. Page 30, my lord. 2021, 22 to 25, 26.
No, my mining permit, my lord, we have issued it, my lord.
Which was
Annexer 3, page 117. Though he has mentioned, issued the document, annexed the document about of 3 years, my lord. Our document says it is for 2 years. We have annexed that document in our affidavit, page 117. Same document, my lord, there are 2 copies.
well, not him. I'm not on that.
Oh.
This document,
My lord,
which is page 30.
page 30, my lord.
Have been issued only in favor of the respondent number 18.
Page 30.
And the said period is from 2021-22 to 2025-26.
The petitioner claims his right to carry out the extraction only on the basis of the letter of intent, letter to proceed with the work, which was issued on 29/4/2022 for a period of 2 years. From the communication. For a period of 2 years. That is from 29/4/2022 to 29/4/2022 to 28/4/2024. The learned counsel appearing on behalf of the petitioner, though submitted that the period had been extended as would be apparent from Annexure 5 to the writ petition. However, there has been no order which have been placed thereby granting an extension to the petitioner. Pusto. This court now finds it very pertinent to take note of that on 13/2/2025, the mining permit of the respondent number 18 was issued to the respondent number 18 was cancelled by the respondent number 15. The said cancellation, however, have not been revoked. And it surprises this court to take note of the communication issued by the respondent number 14 to the respondent number 15, dated 6/1/2026. And the communication issued by the respondent number 15 to the respondent number 14 on 9/1/2026, wherein the reference was only wherein permission was granted to the petitioner to carry out the mining extraction without any reference to the mining permit which was cancelled, mining permit which was issued to the respondent number 18, which stood cancelled by the order dated 13/2/2025, which is yet to be revoked. This court also finds it very pertinent to take note of that if the petitioner herein has been granted by the Karbi Anglong Autonomous Council, more particularly by the respondent number 14 and respondent number 15, on the direction of the higher authorities of the Karbi Anglong Autonomous Council to carry out the extraction without issuance of a tender, the same is in conflict with the provisions of where tender is required, public notice. Up 32 of Chapter 6 of the Assam Minor Minerals Concession Rules 2013. Inasmuch as there cannot be an independent right created upon the petitioner by the respondent authorities, that is the respondent number 14, that is the respondent numbers 11 to respondent number 15, in violation to Chapter 6 of the Assam Minor Minerals Concession Rules 2003. 13. In the backdrop of the above, let this now consider consider the challenge so made to the communication dated 13/2/2025. The communication dated 13/2/2025 cancels the mining permit which was issued to the respondent number 18. Neither the PWD department, neither the respondent number 18 nor the PWD department have challenged the said cancellation. The petitioner have also not shown that by way of an order, the period of the contract which was issued in favor of the petitioner have been extended. Consequently, as the respondent number 18 have not approached this court by filing the present writ petition, the petitioner independently does not have a right to approach this court by filing the present writ petition, for which the present writ petition cannot be entertained. Accordingly, the writ petition stands dismissed.
But before my learned friend starts, there's one aspect I must point out. My friend here has been appointed as standing counsel very recently. Earlier set of standing counsel, I don't know how this has crept in. If your lordship has a look at the affidavit. A joint affidavit has been filed on behalf of 2, 3, and 4. And 4 is a respondent arrayed as party by name. And he naturally does not have the power to represent him. Otherwise, my lord, if your lordship proceeds on merits, I've seen that the issues have been answered. The affidavit takes care of the issues.
File number 1. Wakalat number 5. Wakalat number 5. Who is Mr. Osim Sharma?
I am not.
And what is your name? You will not file wakalatnama?
So he has been appointed just last week. And
No, you have not filed wakalatnama.
Perhaps it is not required, Malas, perhaps because standing counsel.
The standing counsel of what?
Oh, no, Malas, no,
respondent number 4, he has not filed.
not fine.
You are not the standing counsel.
He is the standing counsel for the assembly,
2 and
place
3, Malas.
2 and 3. But for 4, he does not have the power of this.
What is service upon respondent number 4? Respondent number 4 is a person by name.
By name.
And this wakalatnama earlier was signed by one Dulal Pegu. Who is he?
We are not aware, perhaps. We are not.
Who is Dulal Pegu?
But strangely, my lord, the affidavit in opposition, if your lordship sees,
Is filed by Dulal Pegu.
all 3, my lord. All
He
3 and
is
signed by Dulal.
Currently working as the secretary. So therefore, that person has to appear. Who has already signed the wakalatnama earlier?
Just
Where is he?
don't know whether his name is shown or not.
Anyway, what is your case? You have been issued a pass,
Pass, Lordship.
and after pass you were thrown out,
Lordship.
isn't it?
Agent,
And what is your stand?
Stand this, my lord, what had happened? This granting of pass is all considered by a committee known as the press something committee, press reporters committee. Now they took a decision. If your lordship will just take up the affidavit in opposition, everything is reflected. If you're first, what happened was annexure 1 at page 23, one person claiming to be editor of some daily Gana submitted this application for the petitioner. The 2025 winter session of the Assam Legislative Assembly will be
Is
held.
this your photograph?
Lordship.
That's you. Okay, then
It says that senior journalists of our newspaper will be presenting news, etc., etc. Then the committee held its meeting. My notes are at page 24. In the meeting, if your lordship kindly turns the page, in fact, may I read the whole thing? The committee received 55 applications from media houses based in Gauhati addressed to the Secretary Assam Legislative Assembly for issuance of press gallery pass to the press reporters as well as building pass to the camera persons and photojournalists. Out of 55 applications, 49 applications have been found in order after proper scrutiny by the committee, and rest 6 applications have been rejected due to non-fulfillment of required norms. After scrutiny of the committee has prepared a list of media persons on the basis of 49 applications and recommended the list in the meeting and directed the Secretary PRC committee to submit the list to the Secretary Assam Legislative Assembly for issuance of press gallery pass and building pass as per list annex. During scrutiny, the committee found that one application from editor of Dainik Ganahongbat, Gauhati, with a request to issue one press gallery pass to Sri Hemanta Sharma. In the meeting, the committee wanted to know whether the Daily Ganahongbat newspaper has been publishing regularly or not. Therefore, the committee has directed the Secretary Press Reporters Committee to inform the decision of the committee and to request him to submit current latest publication, few copies of Dainik Ganahongbat newspaper before the committee office within 2 days from today, that is 18/11/25. The committee has reiterated its earlier decision that due to limited seat in the press gallery of the house, the press gallery pass and building pass will not be issued to freelance journalists, portal journalists, weekly newspapers, bi-weekly newspapers, fortnightly newspapers, and monthly publications. In addition to this, the Press Reporters Committee will have to look into the security situation of the House while assembly sessions are running. Therefore, the committee is bound to verify and scrutinize all doubtful applications received for issuance of press gallery pass and building pass to the media persons for coverage of proceedings, etc. Now, the secretary immediately contacted them asking for the publications as decided. Now, they did not respond. Then this application was
rejected.
Well, this was later on
23/11.
23/11. It was rejected. Therefore, thereafter, my lord, on 24, if your lordship kindly comes to page 14 of the writ petition. I'm sorry, my lord, page 13 of the writ petition. This time, this same Hemanta Sharma says that I am a freelance accredited journalist by the government of Assam. I need a media gallery pass for the assembly session to be held from so and so to so and so. And your lordship will peruse the last sentence, man.
Then?
And he concealed the fact that his application was already submitted on behalf of Dainik Hongbat. And thereafter, at the lower level, someone made a mistake and issued this pass that the petitioner has annexed. This mistake was detected by the authorities and the pass was immediately converted at page 28 of our affidavit. Since he now claims to be a freelance journalist, the earlier pass that was mistakenly granted was immediately converted and he was informed over telephone that your pass has been changed. In spite thereof, with the earlier pass which was converted, he tried to force his way in. And that is when he was prevented by the security.
Limited area press gallery pass 2F. Now here it was converted to
Assembly premises,
not inside building.
that because that was the decision taken by the in view of limited seats,
Hmm.
only to the regular newspapers and regular television channels. It was decided to given, and freelance were supposed to were not given inside the gallery, and that is why it was converted. And this converted pass was given, informed to him. In spite of that, using the mistaken pass, he tried to force his way in, and that is when the security people stopped him. That is, in a nutshell, that is the case. And the fact that he was informed, we have stated at paragraph 8, and we have also annexed the telephone records.
Now, do you have any rules for the purpose of providing the pass?
No, this, it is entirely left to there are very few seats. So this committee is given the authority that whenever there is an assembly session, this committee is an independent committee comprising of journalists, reporters, etc. And these are not, merely employees of the assembly secretariat. So they take a decision, and this time it was decided that only the regular and the popular media houses will be given, and freelance people will be given, since there are limited seats, they cannot be accommodated. And it is not just that only he was prevented. All freelance journalists were not granted.
Now, this was converted when? Annex of a Roman file, page 28.
Immediately, my lord, as soon as it came to the notice.
Then how did he get the copy of this? Means you issued this pass on, you had issued a pass
Yes, ma'am.
on a particular date.
Ma'am.
What is the date of this document?
24.
Page 14?
Page
14.
এখনো date কি? This is his identity card.
No, page 14, annexure Roman 3.
Oh, no. Date is not indicated.
Annexure Roman 3 to the writ petition.
Both these passes must be 24/11, because we say that on 24/11 itself we informed.
How do we know that
Because he applied on 24/11.
On 24/11, this pass was issued?
And the same day perhaps it was converted and he was intimated. We have made the statement in paragraph 8.
Understood. How do we know about this thing, that it was converted and informed to him that the pass was only limited to assembly premises?
Well, that is a statement we have made in the affidavit, and we have also annexed the phone records at page 27. This outgoing call at 247.
This is whose number?
If your lordship takes up the affidavit in the where petitioner has given his own number, your lordship will find the same number in the page 27.
No, annexure 2, page 13. You have that phone number, na? 835 681 9616.
Yes. Yes. It is the same number.
You called up and informed them.
At 2:47 p.m. And that is a categorical statement in the affidavit.
How do they take into account this aspect?
তার ভিতরে আমার দিচ্ছেন না reply।
Here he says that he was never informed.
Hmm.
And you have mentioned this as paragraph number?
8 one.
That nothing was informed regarding the cancellation and cancelled only one day prior to the sitting of the assembly. On to the impact, the authorities called upon the deponent and according to the deponent. Till assembly premises was denied to you. There's no guidance for denying of entry to the chambers. Now, so you have no guidelines on what basis you are going to choose?
There are no specific guidelines, but at least I had asked him to have a word with the secretary, to the assembly secretariat. There are no specific guidelines. It is left to the committee to take a, depending on the situation, they take a call. There are some guidelines in the pipeline, I think at the draft level. But
That
as of-
means legislative assembly chooses whom to give and whom not to give?
that is why it has left it to a committee to take a call.
Designation as to who are the members of the committee?
It is indicated in the minutes itself.
Not
there-
there. Read it.
If your lordship sees the page 24, and these are all independent journalists and media people.
How did you constitute this committee? For the
Constitution,
purpose of
there is a
constituting
provision
a
for
committee, you must be having either some guidelines or is it just the
Well,
basis?
these are the rules and procedure for conduct of business of the assembly. Under chapter 25, there are provisions for constitution of various assembly committees, but unfortunately, again, this press committee does not find place in this.
Or because what I'm saying is this is a his repetition may not be as regards the inquiry, it's okay, that it's not looked into. But whatever may be, there might be a case of where there might be freelance, there are a lot of freelance here, journalists, they may also have a right because it is after all the fourth pillar of democracy.
The only difficulty is nowadays, your lordship is aware, there are, when we take into account freelance journalists, we now have to take into account all these podcasters and everyone will come within that definition. So it might be a very, very large group. And inside the assembly, I haven't.
Most of time the print media was okay. Print media was holding the fort, but today,
Yes,
you think that the print media continues to hold the fort, or even the TV journalist only holds the fort? As of today, there are many who are, you have big personalities
True,
who
true.
have been earlier with NDTV. They are no longer there. They are freelance.
Yes.
So you
True.
won't even provide persons to that of those calibers to enter.
The guidelines have to be there ultimately. That is what I am given to understand. My friend, and in fact, I am also very newly associated with this, in fact, only last week. I am given to understand that there is some guidelines because of what has fallen from your lordship. There is some thought process going on.
There has to be, because nowadays you are not restricted.
In fact, they can, what they can perhaps do is maybe have a certain percentage from one particular category, another
Have to
percentage.
have, because taking into account nowadays, you are here, what you are mentioning out here, look at this. Here you see that you are only going to provide it to those weekly portal journalists, will not be issued to freelance portal journalists, weekly newspaper, bi-weekly newspaper, fortnightly newspaper, monthly publication. You are not going to give it to India today also? No, my question.
Yes, true. Absolutely.
Isn't there something very inconvenient that you cannot accept this type of, this is not the, if you are giving it to journalists and nowadays we see out there the print media and even the television media is losing ground to the social, the portal media.
True. Some very famous personalities are now independently.
They are mostly there.
Yes.
We are taking out the
This takes out all of them.
newspapers like the Hadini out of it. You take out people like a journalist from Hadin cannot go. If he is attached with Proceeding, he can go there.
True, true.
So it can't be on. It seems to be on.
The only difficulty that arises, these applications come at the last minute, and I haven't
You
entered the.
you can always regulate when the applications are required to be filed.
No.
You can always say that application has to be given 36 hours before that or 40 hours before that for 45 hours.
And if there are some notified guidelines, then it becomes easy.
Unless you don't have a guidelines, the action will be unreasonable of
Yes.
restricting somebody.
Yes. Or maybe even put percentage on each category, and on a first come first serve basis we can give.
Now, how do we know that this pass was issued on that 25th,
Which one?
24th, page 28?
Paragraph 8 itself is indicative. Paragraph 8 from the beginning, if you're.
So here it also does not show a signature or anything to that effect. So you must be having a portal, but when you are getting this in the portal, there will be some data provided out there that this was produced at this came into this was issued at a particular point of time.
That is why they are indicating the time. If your lordship will kindly come to paragraph 8 from the beginning.
Yeah, the pass will show or some records will show. How has he mentioned about the time?
Electronic records is
Will be available somewhere that this pass was issued prior to that. Did you cancel the earlier pass?
yes.
When?
Well,
The cancellation has to be also somewhere.
Your lordship will kindly come to page 19, paragraph 8. This is how it reads. Obviously, I cannot improve upon what has been stated, but the exact statements are like this. That with regard to paragraph 4 of the writ petition, the answering deponent begs to state that the petitioner has submitted the application dated 24/11/25, concealing the fact that his earlier application dated 11/11/25 was rejected by the Press Reporters Committee, Assam Legislative Assembly.
But did you inform him about the rejection?
The rejection. Yes, yes.
When?
That is only on coming to know about his rejection. That is when he filed the second application.
When did you inform?
All those details are not here.
You have not informed. There is no materials out there. How do we know that you informed?
Otherwise, there is no question of him making a second application. That is why, if your lordship kindly comes to the writ petition, your lordship will kindly come to his writ petition. Page 13, your lordship will find he does not mention about his earlier application on behalf of that Hongbar. And this application is dated 24/11. And now he says, I'm a freelance accredited journalist. And this rejection was dated 23/11. Had he not known, he would not have filed a second application.
The counsel for the petitioner, tell me, is this the communication which was issued by your editor to the secretary, page, annexure 1, page 23.
Next one is a identity card, annexure 1,
Page 23.
page 23, affidavit.
That is the annexure 1 to the affidavit.
Affidavit. Lordship, this is communication.
If this was the document which was issued, then why did you file another application?
Lordship.
There was no necessity for you to file another submit application.
Lordship.
If this was the application issued,
Lordship.
yes, there could have been a need of it
Lordship.
if you had known about your rejection.
Actually, I am not aware of the rejection, Lordship. Thereafter, subsequently, I filed
Then why did you file the second one?
second one.
My question arises
okay.
there. Why did you file the second one? More particularly,
Lordship.
when on one hand, if this is the document which is there,
Lordship.
is
Lordship.
being submitted by your editor,
Lordship.
why you have now been put at a, if you, otherwise the daily Ganosongbad,
No.
you are a senior journalist
Lordship.
in that thing. Now, if that be so, then why did you put it in annexure 1? You don't mention anything about anything, but you say that this is you are a freelancer. It doesn't say anything that you have put an identity to the effect that you were the senior journalist of Daily's Ganosongbad.
Actually, the petitioner did not inform us, Lordship. Petitioner did not inform us, Lordship, that they are.
Whom?
I'm a petitioner, I'm a client, Lordship.
Didn't inform you?
No, Lordship, this is under the file by.
Huh?
This is, Lordship, actually, this case was filed by some other councils earlier, Lordship.
Not on that.
Lordship.
My question
Lordship.
therefore is
Mm.
the filing of the second one.
Second application, Lordship.
We suppose that you knew about your rejection on 23rd and therefore again requested,
Lordship.
but without mentioning that there has been already a
Lordship.
rejection.
Lordship.
So therefore, if you have not come with the clean hands before the authority is concerned,
Lordship.
can this court exercise the equitable jurisdiction? My
Lordship.
question is there. Although you have made one needs to ponder
Lordship.
as to whether such action on the part of the legislative assembly only to pick and choose those journalists would be proper.
Lordship.
That would be a thing which we may consider on some other case, better case placed, but not here. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petition.
I'm sorry to interrupt, my lord. I have just been informed that there is one set of guidelines which provides for, there's just one provision, your lordship may like to. It deals with all car passes, VIP passes, etc., etc. There's
But
just
they
one
require, if
for media, there is only one provision.
we have a legislative assembly, we got a new building, and till date, if there is no guideline.
Clause 17 is the only provision for media gallery pass. With this passage of time, I agree, my lord, there needs to be a better set of guidelines. Particularly now that they have a new assembly building.
It is made recently in 2021. But it seems that the foresightedness of the Assam Legislative Assembly is missing. They never thought that within a 5 years' time there will be a more portal, the portal journalism would take effect.
And perhaps also that they will themselves have a new building. That also they did not foresee.
No, the new building would be completed.
No, assembly building is already.
No. In 2021, it was not completed. They did not foresee that within 6 years it would be completed. It started long time back. I heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. I. Chaudhary, the learned senior counsel assisted by so-and-so appears on behalf of the respondent number 2 and 3. First up. The present writ petition has been filed by the petitioner, being aggrieved by the actions on the part of the respondent authorities. Seeking an inquiry into the incident dated 25/11/2025, na? 25. When the petitioner was removed from the press gallery in spite of the petitioner having been issued a pass. The petitioner have also sought for a direction, thereby restoring the right of the petitioner to attend the assembly session in future. The brief facts which have been mentioned in the pleaded in the writ petition is that the petitioner is a freelance journalist who have been issued a identity card by the Director of Information and Public Relations. On 24/11/2025, the petitioner submitted an application for media gallery pass to the Secretary, Assam Legislative Assembly. And on the same day, a pass was issued, thereby which is valid for a period from 25/11/2025, 9 a.m. to 29/11/2025, 5 p.m. In terms with the said pass, the petitioner was permitted in the press gallery pass bracket 2F on 25/11/2025. The petitioner was forcefully removed by the security personnel. And the petitioner, being aggrieved, had submitted a representation on the very date. However, no steps have been taken in terms with the representation. The petitioner had approached this court by filing the present writ petition. The record reveals that this court issued notice on 4/2/2026 on behalf of the respondent number 2, 3, and 4. Counsel, Mr. A.K. Bhuya had accepted, Mr. N.R. Sharma had accepted the notice An affidavit in opposition was filed on 6th of April 2026. In the said affidavit in opposition, it is categorically mentioned that on behalf of the petitioner, an application for media gallery pass was received from the editor Daily Gonosongbad on 18/11/2025. For the winter session of the Assam Legislative Assembly, that is with effect from 25/11/2025 to 29/11/2025. A meeting was held on 18/11/2025, wherein the various application was held by the committee in charge of issuance of passes. Out of 55 applications, 49 applications were rejected. In the minutes of the meeting dated 18/11/2025, there's a specific reference to the petitioner's application, wherein it is mentioned that as it was a decision on account of lack of space, only to provide passes in the press gallery to daily newspapers. An inquiry was an inquiry was sought as to whether the newspaper for which the petitioner's application was submitted, that is Doinik Gonosongbad, was in publication. Pursuant thereto, on 23/11/2025, as the petitioner could not provide the current or the latest copies of the newspaper, Doinik Gonosongbad, the petitioner's application was rejected. It is further mentioned that inadvertently on the application which was submitted by the petitioner on 24/11/2025, a pass was issued for the press gallery without considering the rejection of the petitioner's application on 23/11/2025. And thereupon, when the said aspect came to light, immediately the said pass which was issued earlier was converted to a pass, thereby permitting the petitioner access to the assembly premises, but not inside the building. It was also mentioned that the petitioner was duly informed by one Parvati Kashyap by telephonically and and the evidence to that effect have been enclosed as Annexure 3 to the affidavit in opposition. The record reveals that the petitioner thereupon submitted a reply to the affidavit in opposition on 14th of July 2026, wherein it was mentioned, categorically mentioned, that the petitioner was never informed that his pass was converted, or for that matter, his pass was cancelled. He further submits that there was no guidelines for denial of entry pass to the journalists. In the backdrop of the above, this court heard the learned counsel appearing on behalf of the petitioner, as well as the learned counsel who appeared on behalf of the respondent number 2 and 3. During the course of the hearing, this court inquired as to whether the Assam Legislative Assembly Secretariat and Legislative Assembly has a set of guidelines for issuance of pass. Mr. So-and-so, the learned counsel appearing on behalf of the respondent number 2 and 3 submitted that on 8/12/2021, a set of guidelines for issuance of pass have been framed. Insofar as media gallery passes are concerned, it is mentioned that media passes would be issued on the recommendation of the editor-in-chief of the concerned media house and the press secretary of the Assam Legislative Assembly Secretariat. Admittedly, the guidelines do not refer to any they do not take note of any freelance journalism, as well as the and freelance journalism, as well as, and restricts itself to media houses. This court would not like to further comment on the said aspect. But taking into account the present scope, the present, but taking into that at present the journalism is not only restricted to known media houses, but the scope have enlarged manifold, thereby including portal journalism. It is expected that the Assam Legislative Assembly shall duly consider the said aspect, taking into account that journalism has been considered to be the fourth pillar of our democracy. Coming back to the facts of the present case, it would be seen that the petitioner herein, the counsel for the petitioner herein duly admits that the editor of the newspaper, Daily Gonosongbad, had submitted an application on 11/11/2025, which was received on 18/11/2025, requesting that the petitioner should be granted a media gallery pass. First, this court, during the course of the hearing, inquired with the learned counsel appearing on behalf of the petitioner as to what necessitated the petitioner to submit another application on 24/11/2025. When they said application, there was already an application, unless and until the petitioner had due knowledge that his application was rejected on 23/11/2025. The learned counsel appearing on behalf of the petitioner submits that he has no instructions in that regard. This court further takes note of that in the application which was submitted by the petitioner on 24/11/2025, there is no mention that the petitioner's application was earlier rejected or there was already an application which was submitted. First, it is further seen that on 24/11/2025 itself, an application was filed. The petitioner was issued a pass, thereby permitting the petitioner to the press.
Now, what is
To the
stated
press
is,
gallery.
yes, at 1:35 it was issued, it was noticed, thereafter it was cancelled at 2:43 and
Press
intimation
gallery.
was given at 2:47.
This court takes note of paragraph number 8 of the affidavit in opposition, wherein it is mentioned that the press gallery pass, which was issued to the petitioner, was issued at 1:35 p.m., which was upon notice, which upon being, and the said aspect when it came to the notice of the authorities concerned, the said pass was converted into at 2:43.
And intimation was given to him over telephone.
2:43 into an assembly premises pass, not inside the building. The said intimation was given to the petitioner at 4:37 p.m. 2:30. No, you have called up later on 4:37. At 2:47 p.m. At 2:47 p.m. Taking into account that the petitioner herein petitioner's pass herein was modified and or cancelled and was issued a pass only for the assembly premises, not inside the building, the removing of the petitioner from the press gallery, in the opinion of this court, cannot be faulted accordingly, and more particularly when the petitioner have failed to disclose as to why the petitioner has filed a separate application on 24/11/2025, in spite of there being an application filed on 11/11/2025. Considering the above, this court does not find the present case to be a fit case for interference for which the petition stands dismissed. Mr. R. Sinha, the senior citizen, what happened?
Your Lordship, the petitioner, he went to an ATM which is located at Ranbagar, FC Road. Now he's put the ATM card inside the vending machine, and thereafter he pressed the PIN code, the PIN of the ATM. And thereafter the ATM got stuck inside and the money did not came out. neither the ATM.
ATM card stuck inside.
Yes, after I pressed my pin. Now the ATM card also didn't came outside and the money was also not coming outside. Now there was a number pasted in the inside the room of the ATM vending machine. I called that number. They said that you come at 2 o'clock. We will give the ATM card got stuck inside. We'll give you the card by 3 o'clock. So by that now no message, nothing came to my mobile. I went back at 2:30. Nobody came. Till 3 o'clock I waited. Then I went to the Senikuti branch. They said me that you have been siphoned of 41,800 something. And you need to go to the Panbazar branch. I went immediately to the Panbazar branch. The ATM in charge was there. I have specifically categorically named him. He is Varun Chaudhary. He told me that you give a complaint. You give a written complaint. We'll look at it. And when the persons who are operating the vending machines, they come for the maintenance or depositing, they'll collect the card and give it to you. That never happened. I filed a complaint before the bank rejecting one single stroke, saying that the SMS was delivered. So therefore, the bank has no liability.
But you filed a complaint
Yes, I filed a
on
complaint.
the date itself.
Yes.
You have been siphoned off
Yes.
41,000.
Yes, everything. It is on record, Your Lordship. Then I went, of course, then the AGM misbehaved with the person.
I'm not concerned with that.
No, what
You
I'm trying
want
to
the
say is
money
that
back or what is your case now?
my case was that the amount was siphoned.
Now what do you want?
Now the thing is that they say that I have withdrawn from the another bank. Now, in the name of investigations, they have not collected the CCTV footage. They have not collected the videos, which I have repeatedly requested them to do so. And they come up and say that I have withdrawn it from the other bank. How could they have said that? Secondly, I have lodged an FIR also. The police has also done some sort of investigation, not.
But RBI have also rejected.
Yes, that was beyond time period, Your Lordship, because that. I must admit that.
So you want the 41,870 back?
Along with the interest and compensation.
Huh?
Along with an interest and compensation.
The compensation you are asking?
I have not mentioned anything that I have left to the court, Your Lordship, although I have prepared a charge.
Now, what happens? There are guidelines of the RBI.
Yes, Your Lordship.
What is that?
In fact, Your Lordship has referred to those guidelines also.
Where?
In one case, Authorised.
At last, that person got the money, not from the state bank. I think Airtel gave the money.
Yes, Your Lordship. The issue was like this. Your Lordship has discussed in details 6, 7, 10 and 12.
Interfered there.
No, the division bench, I would say in my humble submission, the law still holds the fields why I'm saying so. The division bench has interfered only to the aspect that in the interim, Your Lordship has directed that the money is to be given by the state bank. And further, in the course of
that. Division bench interfered and said when it disposed of, first they gave a stay.
Yes, Your Lordship.
Then the matter when the division bench said that the single judge will again decide that.
Yes, Your Lordship.
But my question is, court being an intra-court appeal, they cannot again remand it back to the
Correct,
court.
Your Lordship.
That is the law.
Yes, Your Lordship.
Supreme Court many judgments.
Yes, Your Lordship.
The exercise of jurisdiction which I do here as a single judge, my exercise is same that of the division bench.
Correct, Your
Therefore, it is never said to a statutory appeal or it's an intra-court appeal.
Right, Your Lordship.
So therefore, there is no power of the division bench to remand the matter back to this court.
Yes.
And therefore, I say then not before me.
It was taken up by finally Justice Manish Chaudhary, but yes, Your Lordship.
So therefore, this is the law.
Yes.
So the division bench has no power. Yes, the division bench should have the power for remanding in a case where I dispose of the petition at the stage of motion, and thereupon the division bench interferes with that order. And then it may be remanded back because pleadings are to be filed by the parties.
Correct, Your Lordship.
Then only the division bench can do so. Because the pleadings normally are not filed in the writ appeal. Writ appeal pleadings are always filed in the writ petition.
In fact, your lordship, the other day, this is out of the context, I was discussing that judgment with my senior and it was finely tuned. In fact, today morning also when I was reading it, your lordship has discussed the provision of the RBI guidelines 6, 7, 12. I was reading through it. So it was a case of no liability and it came under 7.2. Why? It was described in details, your lordship. But when the division bench passed the interim order without discussing on merits and anything, that why it needs to be
Therefore,
said.
the question now is, but that is a case of a cyber fraud.
Cyber fraud, your lordship.
But here is a case where your ATM has been used.
Yes, your lordship.
ATM use, cyber fraud is, there is a time period mentioned. If I see, if I remember
3 days
correctly,
within.
it was some clause 7.
Yes, 3 days.
You have to mention in all these things. But when it is a case of ATM fraud, what is the, how does the Reserve Bank do it?
Your
Yes,
lordship.
you are for the Reserve Bank. How do you deal with it as per your? Use the mic there? No, there's a mic. Yes.
I think this case, Major, I have the instruction to say that
Mic, yes.
my submission is confined to the extent of the rejection of the ombudsman order.
No, I am not on that. My question is, what do you do? How does the Reserve Bank deal with this
My lord, regarding the
regarding an ATM fraud?
regarding the cyber fraud, that notification is the 6th of July 2017. My lord. The ATM fraud, I'll have to obtain instruction from
We are concerned with an ATM
my
fraud.
lord. I'll
This is not a case of a cyber fraud.
my lord. I'll have to
Cyber
obtain
fraud will
instruction.
have a different thing where whether you know or not, because a person has to intimate, because when it happens in respect to a cyber fraud, then what happens? The merchant or
My
the
lord.
merchant bank
My lord.
which is concerned. Although on account it is being shown that the amount has been transferred, but then also in effect, the money still remains with the merchant bank for particular hours.
years. Yes,
And therefore they can just recall it
My
or
lord.
decline it.
Yes, my lord.
So therefore you have 7.
My lord.
So 7 gives a year. If you delay it beyond 48 hours, it does not.
My
It
lord.
goes outside the
Yes,
hands
ma'am.
of that merchant bank
Precisely.
who has given, so therefore he can recall it. So therefore you have this NEF, IMPS and all these things.
Right.
But my question is, what do you deal with? How do you deal with ATM frauds?
My
Because here is a case where ATM card was inside, remained inside, what is Mr. Sinha has said, remained inside and he lost 41,000
Right.
more. That is one. Secondly, what happened to, where did you get that ATM card? Did you get the ATM card?
No, my lord, our record reveals that the transactions that took place, the alleged transaction, they didn't take place in our ATM. It took place in an ATM of a different bank. Industin Bank ATM.
And
So
so you, when the vendors or the persons who keeps on or changes the money
Yes,
or refills the money,
yes, madam.
those service, they did not find the ATM
No,
card.
because we have no instruction on it, because the when the complaint came to us, when the particular petitioner came to us, we went to the account statement. We started looking what happened, what transpired. This is the annexure B page
Tell
66.
me, when did the incident happen?
Incident happened on my lord. 17/6. 17/6. 2023. That day itself, my lord.
Understood. What is the time of the incident? When did you go, Mr.?
At morning 9 o'clock, your lordship.
9 a.m. to 8,
17/6, 2023.
17/6,
2023.
23. You went there. Then, which bank?
SBI, your lordship.
SBI, which branch?
SBI, no, first I went to the ATM which is situated at FC Road.
You put the card where?
In the SBI ATM
Where?
at Uzan Bazaar.
SBI Udhan Bazaar. Then?
The ATM which is located at Uzan Bazaar, FC Road. Thereafter it got stuck. I rang the a number pasted on the inside the room. Later on, I came to know, the police informed me that number was, and in fact, the bank official informed me that numbers is not the helpline number. That number was of the fraudster who have pasted it. So my issue is that when the SBI officials does not have the control over their ATM vending machines and anything, anybody can come and paste anything. And in fact, it was pasted there. They came and they took the ATM from there thereafter, and they withdrew it from the other ATMs. And therefore, I'm saying the story is like this, Your Lordship.
They opened it.
They committed some fraud in the ATM vending machine. So as soon as I was not aware of it. So as soon as I inserted the ATM vending card, it got stuck inside after I inserted the PIN.
And when did you give your call?
Immediately thereafter, Your Lordship.
No time limit.
Within 5-10 minutes, something like that. Then they
Did you
told,
Did you take photographs? Number? No. Anyways, next.
then I called and I told them that I called the number and I told that my ATM got stuck inside. They told that they'll be coming at 3 o'clock.
3 o'clock.
Yes.
But why were you waiting till from 2:30? You just said 2:30.
Your Lordship?
You just said 2:30. You have been waiting there.
Yes, I went there at 2:30. I have been waiting till 3 o'clock.
They said that they will come at 3 p.m.
3. I waited from 2:30.
Then
I went to the Seniguti branch. When nobody came, I smelled something foul and went to the Seniguti branch. They said me that an amount of 41,000 something 800 something has been siphoned from my account.
how did it? Is this your home branch, Seniguti branch?
Yes, Your Lordship, but my account is in the Panbajar branch.
So this is not the home branch.
Not the home branch.
Your account is in the Panbajar branch.
Panbajar branch.
Panbajar
So
branch, when did you go?
Immediately, Your Lordship.
At?
I don't remember the time, but immediately I went, Your Lordship.
Okay, then what happened?
There I met one Barun Chaudhary, who was the ATM in charge. He told me
Submit your complaint
that day itself, Your Lordship, a written
on
complaint.
17/6/2023.
Yes, Your Lordship.
Did they give you a receipt?
Yes, Your Lordship.
Time?
Time has not been mentioned, but
Why no time is given?
just looking at it.
Anyways, now then what?
Yes, Your
happened?
Lordship, the time is at 4:09.
Oh, 9, because they will give the time because the period will count. Huh?
Yes, Your Lordship.
This is what I'm saying.
So,
They gave you at 4.09.
yes, Your Lordship, that is at
Then-
page 24. Thereafter, I've been sitting and one fine day they have rejected my, and on
That's okay.
18/6, that
They
is the
have
next day.
We'll take care of that.
Huh.
They have rejected. You have submitted a complaint.
Yes,
That's
yes, yes.
Now, how do you have, what happens as regards this ATM fraud? What are the guidelines of RBI? You find, I'll finish it up, yes. We only look into that. Well, because the thing is like this, there are many other ATM frauds which keep on happening. Just for example, you find it out there in the SBI itself. Now, he says that it is not in SBI, he is this amount of 41,000 was taken from the InBank.
Yes, they were 10.
Thereby, your card was taken out.
Yes.
And what was the time of that transaction of
The
41,000?
time was on that day itself, my lord, 17/6/2023. There were 4 withdrawals of 10,000 each. And
What time?
Time, my lord, I have to find out.
It will be given out then.
The ATM, it's not
Where
much.
where is your bank statement?
I have the bank statement with me, but the
No, you have not enclosed.
Yes, I have given the bank statement, my lord.
Where?
Page
866.
66, my lord.
Okay. Where?
The time is not mentioned.
Time is not.
Time is not mentioned, my lord.
17/6 in the
10,000, 3 withdrawals, 4
Four
withdrawals of 10,000, then it was swiped in one POS shop.
1681.
No. Tell me one thing.
Yes, ma'am.
There is a purchase
Yes, my lord.
of certain amount from a
Wine
from
shop, yeah.
Deepu's wine shop.
Tipu's wine shop, yes, my lord. That day itself, after this 4 withdrawals, this swipe was done in that wine shop.
And what is this shadow
That's what I'm trying.
reverse complaint? Shadow reverse complaint is given. Interest credit so and so, Semtex.
There's a pension amount. Just come. Last was a pension amount.
Pension. Therefore, now, when did you get your ATM back?
No, I didn't got my ATM back. They have not returned mine. I have applied for a new ATM.
When did you get it?
That I have to.
You got it something.
No, I have got a new ATM, Your Lordship. Your Lordship will.
Understood. No problem. Mr. Counsel, tell me one thing. Here, obviously, in the statement, it would not be available. But it will be available as regards in your thing. So what is the time?
That time, my lord, we can
Because
find.
whenever you take out the money from the ATM, there will be a time.
There will be time frame. We can find out that, my lord. Because it's not mentioned in this account statement, but we can find it out.
Because here they have used this Indus in bank where? Which branch? There are many ATMs.
That we are not able to find out because that will not.
Because he says that it happened in.
Yes, my lord. He said that he went to our ATM in Uzan Bazaar, his card got stuck. But as per the account statements, these withdrawals were done in some IndusInd Bank Limited ATM, which is not ours. And also in a particular wine shop, a swipe was made. My lord, we will not be able to know which IndusInd Bank ATM because that is not within our jurisdiction or domain.
Didn't you get your message?
We send our SMS. It's an admitted fact.
Your
that-
Lordship will appreciate one fact that they have not seized the CCTV footage of this ATM.
That is for the police to look.
Police has also not done it.
Police not looking it, will look into it. But my question is, you got the message immediately.
No, Your Lordship. No.
Obviously, the SMS will go.
If the man, if I would have received the SMS immediately, I would have rushed to the branch. Then and there itself, I would have rushed to the branch.
No, you have not rushed. How do I know? Or you would have rushed or not, or you must have thought that something must have happened.
So we see that,
Huh?
that debit amount of 1,870. It was in the wine shop swiping method.
This is a swiping case.
Unless
No,
the
my
PIN number is
But
known.
my lord, I was about to.
Cannot, my lord,
Thing is that
cannot be.
irrespective of the wine shop,
I would have understood if you were outside India, it's a different thing, where they go by the magnetic thing.
It's still
But
open.
here, how can the ATM purchase being made without the PIN number?
that's what my lord, because without the personal identification
In
number.
fact, Your Lordship, I pressed my PIN code there, the PIN number there, and then it got stuck inside.
Understood, but the fact remains, unless there is something to that effect, how does this court hold you? Because this particular person who have spent this money also used it for the purchase of this. Now, what does the police do?
That's what I was
Your
supposed to
Lordship,
come
the
to my
police
lordship.
has given a report, Your Lordship, that is marked as
That
act.
report, my lord, it's as marked as X. If your lordship allows me, I just want to read out what the police has stated in their report. This court had asked for a report from the police upon our filing of the affidavit. Lordship, the police say.
Attention is drawn to the RBI customer protection so and so, which sets out the liability if the customer reports the unauthorized transaction to be 3 days. This is different.
No, my lord, the police have just stated the fact of the petitioner's case in their
The
reply. They
bank
have-
must reverse
And now
the
they are citing the
debits
RBI guidelines, some RBI guidelines. That's what they
Having
will say.
fulfilled all
The police have,
statutory required, the
in a
petitioner so and so is
they have
entitled to
published
refund. Let's say inspector says that he's entitled to refund.
No, that is his guy directing State Bank to refund, my lord. In a sub judice matter, the police job was to
Reported the
investigate.
unauthorized promptly qualifying zero liability. Now, he has failed to understand that this is an electronic banking.
That's what, my lord, and most importantly, my lord, what our submission
You
is.
find out on ATM fraud. This police have not done it properly, madam. Police have not done it. The police, have they visited out there? Where is the mention that they have visited the place?
Haven't, my lord.
That at that point of time, they have looked into the CCTV.
Yes, my lord.
Nothing. Investigation has become nothing.
Lordship will see that petitioner perhaps compromised with the PIN number. No? That's why he has purchased by swiping the.
No, what happens is this, as I have heard from something. In fact, one of my juniors had the same occasion of having it while I was a lawyer, particularly in that Hatigor SBI. They used to have something just above the keypad.
Yes.
And from there, they can gather out what are the PIN codes, what is the PIN. On the basis thereof, they siphon up the money.
I know there are innumerable probabilities in this sort of matters, but
But these
our-
are questions of facts which.
yes,
need
my,
to
our
be
humble
done by way of an
submission in
investigation. This is not a case where, yes, that case which I was dealing with was an electronic transfer.
yes, my lord.
When it's a case of electronic transfer, it is beyond the hands of him.
Yes, my lord.
There, what has happened, if I remember, in the name of purchase, what has happened, certain amounts first initially, because you see, the UPI will use only till 1 lakh.
Yes, my lord.
Cannot use more
Beyond
than
1
that.
lakh, yeah.
It gets blocked. So what had happened, they took out 99,000 through the UPI. And then thereupon with the every 1 lakh each, all these things were transferred to one company, namely Quicksilver.
Initially, in that case, my lord, that SIM was transferred.
Huh.
Yono was installed in their name, my lord.
And it was because of that.
Yes,
It was because of the Airtel's mistake.
my lord.
Yes.
It was
That's
apparent.
why they have paid the amount.
Luckily, it's good that that he was also senior citizen.
Fine.
and got them.
In these cases, my lord, our only submission is that, as your lordship has pointed out, it could have been skimmed. There is one of the probability there may never would have, it could have been shared by the petitioner inadvertently himself. So there are innumerable probabilities in this matter. The police should have investigated.
Because
Then-
they will require two things. One thing is
Is
there.
the card
The card has gone out.
and the PIN number.
The second is the PIN.
PIN number, my lord.
So the card, the moment the card has gone out, means the petitioner lost the card during that period.
Yes, ma'am.
And petitioner called up these people and they must have taken the card, if we believe the version of the petition.
Yes, my lord.
But these are questions of facts.
Yes, ma'am.
Now, unless there is an automatic, which is similar to a Rule 7 for an electronic transfer, Mr. Sinha, there is a difficulty for this court to entertain the petition on the basis. Yes, this court can very well proceed, ask them to investigate in a better manner. That is a different aspect of the matter. Only problem is there. Because let us first find out from him as to what is how the RBI has dealt ATM from.
I'll obtain instruction.
Your lordship,
Lord,
there is
please,
one more aspect I'd
Let
just
us
like to,
counsel on behalf of the petitioner. Mr. So-and-so appears on behalf of the SBI.
SBI, my lord.
So-and-so appears on behalf of the SBI. Mr. So-and-so appears on behalf of the Reserve Bank of India. And Ms. M. Burman, who appears on behalf of the state of Assam. This court have duly taken note of the police report, the report which have been submitted by the inspector, officer in charge, Lota Pisil PS. The said report dated 3/4/2026 in the opinion of this court is not at all satisfactory. Inasmuch as there is no mention whatsoever as to what are the investigation which was carried out by the investigating officer. Under such circumstances, they filed an FIR, na?
yes, your lordship.
The police case, na?
Yes, your lordship.
PS number? File PS number?
It's part of the.
It's part of the affidavit.
It was received on 18/6/2023, Your Lordship.
What is the Lata Hill PS number?
In the report, it is not mentioned also.
Nothing.
It's also not mentioned. I could have
mentioned.
called for the CD.
The complaint was received on 18/6 as per.
Miss M. Burman, the learned government advocate, shall obtain instruction as to what is the police station case number in respect to the report which was submitted on 3/4/2026, and also the case diary, updated case diary as regards the investigation which was carried out. This court have also taken note of the facts which have been placed by the learned counsels appearing on behalf of the parties. Mr. Arsena, the learned counsel appearing on behalf of the petitioner, submits that on 17/6/2023, the petitioner went to the ATM, SBI ATM, located at Uzan Bazaar. And on the same date, he took, while trying to take out certain cash, the petitioner's ATM card got stuck in the machine. Mr. Arsena submitted that the petitioner thereupon called up the helpline number so provided, and the petitioner was advised to remain at 3 p.m. in the ATM so that the officials would come and provide the petitioner the ATM card. It is the further case of the petitioner that the petitioner duly visited the ATM again at 3 p.m. But no official turned up. And under such circumstances, the petitioner went to and approached the Senekuti branch of the State Bank of India, who informed the petitioner that an amount of rupees 41,000 and odd have been debited from the petitioner's account. The petitioner was asked to approach the home branch of the petitioner, which is at Panbajar. Accordingly, the petitioner approached the home branch and submitted a complaint on 17/6/2023 at 4:09 p.m. The complaint was rejected, and thereupon the petitioner's representation to the Reserve Ombudsman of the Reserve Bank of India was also rejected. It is under such circumstances the present petition. The so-and-so who appears on behalf of the State Bank of India submitted that though the petitioner has claimed that the petitioner's card was stuck in an ATM of the SBI, however, the amount which were amounts of rupees 10,000 each, which were taken out in cash, was taken out from a ATM belonging to the IndusInd Bank. In addition to that, there was a further purchase of rupees 1,800 and odd from a wine shop on the same date.
Yes, ma'am.
The legal counsels have therefore submitted that in the instant case, it is apparently clear that the petitioner have compromised either with the card or the PIN number or with both. More particularly taking into account the purchase made in the wine shop has to be not only based upon the physical, or not only based upon the requirement of
using the ATM physically, the ATM card physically, but also inserting the PIN number. The Learning Council, appearing on behalf of the SBI, further submitted that clause 7 of the RBI guidelines of the year 2017,
July 6th, July 6, 2017.
6/7/2017, would not be applicable to the present case, taking into account that this is not a case of electronic transfer. Rather, it is a case which will come with as to whether there was an ATM fraud or not. This court, upon hearing the learned counsels, is of the opinion that the stand of the RBI as regards as to whether there is any guidelines when there is a case of an ATM fraud, as to whether there exist any guidelines to take care of a situation of ATM fraud, have been made by the Reserve Bank of India. Mr. So-and-so, who appears on behalf of the Reserve Bank of India, submits that he would obtain necessary instruction, and if such guideline exists, the same shall be placed. List this matter again on 28/2026, 20.
My lord, 28.
20 August.
20/08/2026, on which date Mr. M. Borman shall provide the updated status of the Lota Hill Police Station case wherein the petitioner has submitted the first information report, and also the case diary. In addition to that, Mr. So-and-so, who appears on behalf of the RBI, shall place as to whether there exist any guidelines, and if so, the said guidelines. Taking into account that the matter has been heard in detail, the matter be shown as parted.
Your Lordship, the SBI Council may be directed to produce the records of how the money, at what time there has been withdrawn from the.
Get the period, huh?
Yes, ma'am. Time.
I've not put it, but you just get the time.
Yes, ma'am.
Because it will be available with you.
Of course.
Because that will, once you get the time, I can place it with the investigating officer. It will aid them.
Yes.
For the moment the time is known,
Yes, ma'am.
you can also locate the IndusInd Bank
Yes, ma'am.
ATM. All ATMs have a number.
Yes, madam.
You can very well say as to which is there. Then the investigating officer can go to that ATM, get the footage, and then investigate. Now the problem is the matter is too getting delayed. Get the point?
Right.
Made the IndusInd the party. No.
I'll file an IL, I'll make it as a party. Your Lordship. Deeply obliged. Your
Deeply obliged, ma'am.
This
What
is
is
regard-
this?
This is
RBI
regarding
court.
promotion to the post of process server in MSCT establishment Nagaon, my lord. And my lord, principally I have challenged how the gradation list was formed. It is a case of the respondents that a common recruitment drive was set out and marks were allotted. And based on the marks obtained, the merit list was prepared, and so the gradation list. Based on that particular gradation list, the subsequent promotion exercise took place.
Oh, you are senior.
I say I'm senior, and the gradation list has been prepared, has not been prepared in terms. And so
Yes, Mr. Counsel.
Yes, Lordship, in this matter, Lordship, we have filed our affidavit in opposition, Lordship.
But I have come up with a reply. It has been filed today morning. I served them a copy yesterday.
Your file reply is not there. Already, Gauhati High Court has suffered one judgment. Any judgment do you want the Gauhati High? taking into account that the reply so filed by the petitioner is not on record, list this matter on 13th of August 2026, on which date an attempt shall be made to dispose of the petition. The registry shall bring on record the said liberty granted to the petitioner to mention the matter for.
Publish.
What is this? You have chosen a different client nowadays.
My lord.
Huh?
My lord, for convenience, my lord, Rashmi, we wish to take item number 15, my lord.
Oh, that matter.
Yes, my lord.
Cancellation of tender, Lordship.
My lord, in one point, my lord, they are saying that their validity period had expired, my lord. They have cancelled the tender, my lord, alleging that the validity period, tender validity period had expired, my lord.
Yeah.
This is that cancellation, my lord, ground of cancellation, my lord. They have cheated on the matter.
The water resource department was behaving like PWD.
My lord, yes,
Huh?
exactly, my lord. Now, my lord, they are saying that no, another work has come up, so we'll stop this and new work will continue, my lord.
Then,
This is happening, my lord.
anyways, we need to finally dispose it of.
My lord. Manda to it, my lord.
We finish it up on Monday, 2 p.m. Taking into account that there is an interim order and there is an urgency expressed by Mr. R.M. Das, the Standing Counsel of the Water Resource Department. Mr. Das, you belong to the government. Government I don't allow nowadays. I'll have it some other day. When?
There is urgency.
On account of paucity of time, list this matter after 6 weeks.
No, no.
No,
Monday,
no,
Monday,
no,
Monday.
no, no.
No, Lordship, there is
Government
urgency.
I don't allow nowadays. Taking into account on paucity of time, the matter could not be taken up, for which the matter stands adjourned to be listed on 14th of August 2026. Interim orders passed earlier shall.
It makes too long, Lordship. May I request, Lordship?
Oh, government I don't allow nowadays.
Obligement.
Because the government has to act. There is always a quid pro quo. If the petitioner has urgency, the government also should have urgency. Isn't it, Mr.? For the petitioner, if you don't have the interim order, the government would have been sitting out there.
Yes, yes, my lord.
Why should this court think about the government? Isn't it?
Flood season is near, flood
Huh?
season is approaching,
Flood-
flood season is going on. That's why there is an urgency because the embankment construction is there. There is an interim order because of which no tender can be issued, Lordship. There is that's why.
Why on the first occasion you did not give it? Or you did not think that there would be a cloudburst in Nagaland? No, something to the effect.
Matter for 4 months.
Huh?
They have seated over the matter.
Yeah.
Idle for 6 months, 4 months.
And
4 months
then the
means
Water Resource Department
MCC
expresses urgency
MCC has come.
time when we are in the midst of floods. Huh?
That's why, Lordship.
Okay. You are department. Okay, if it is a department, then agar order to rakiba. 2 p.m. Being a department.
Yes, Lordship.
My lord.
Yes, 16. Yes.
This is that matter, my lord, where your lordship said in the page 39, the last order, my lord,
Oh, this one.
that
The-
recasting.
Our stand will be same likewise the previous affidavit, my lord.
We do one thing, the records, let us produce get the records of the earlier petition here.
It's already annexed some.
We've only
That
annexed the
can also be
orders.
done, my lord. The
Only,
lord,
only orders have been filed, not the.
And then
They have-
you can very well say that you rely on the stand of this.
that can be said.
Yeah.
Can be said.
Affidavit they have
Should
annexed
we
into.
put it that you don't want to file an affidavit?
Yes, my lord. It is my
And
instruction.
shall rely on the records of WPC number 4043 only
Yes,
2025.
yes. That is my instruction. I have got the
That
instruction.
order is anyway passed on the last occasion by your lordships. That order is on
But
the.
I have already said.
Yes, madam.
Page 3.
And on account of the stance so taken by the respondent, here the petitioner withdrew the so and so else any. If the second one, the privy did not file.
It's already available on.
Not the respondent, which is already available on record.
Yes, ma'am.
For the 1, 2, and 3 or 4 and 5? You are for the 1 and 2, which should have been given. They also agree to give it,
Yes, ma'am.
but they don't want to give it. What happened to the others? They have left you. Huh? This matter on, we have it next, 20,
August
20, August. Earlier matter will fix.
13th, minor this, if it is not inconvenience.
13th.
13th, if it is not inconvenience.
This matter on 13th of August 2026.
My learned friend is not 13 is okay.
Which date? Footstep. The registry is directed to tag the records of WPC number 4043 of 2025, which stood disposed of by an order dated
That is my lord.
14/5/2026.
14/5/2026.
Mr. H.K. Das, the learned senior counsel as well as the standing counsel of the Gauhati High Court submits that the stand of the Gauhati High of the respondents would be the stand which have been taken in the affidavit in opposition filed in WPC number 4043 of 2025. And the respondents hence would not file any separate reply and would rely upon the affidavit filed in WPC number 4043 of 2025. তার পিছত লিখিব, the registry in view of the above is directed to tag the records of so and so which to disposed of on so and so. ঠিক আছে?
Extremely great.
Fine. But can it be 20 million, if possible?
He said,
No
I
problem,
said
madam.
20.
Some
No problem.
difficulty.
28.
13, some difficulty.
28, madam. No problem.
28.
No problem.
Mr. Das doesn't want to go by the date. He likes the date 13.
No, thank you.
If
Extremely
it's
grateful.
Thursday, Milord, then I don't have any choice. It has to be Thursday.
20. Thursday.
Leave it on 20.
20. Extremely.
Be it pleases your lordship.
Hmm.
Lordship on dated 8/6/2026, lordship had
Hey, Mr.
directed.
Das, when did I fix the other matter? That matter where the lady was there, what was the name? I forgot. That execution case.
Yes.
Next week, na?
Yes, 38.
Next week.
Next.
Okay.
Lordship on
Because of
eight-
the statutory first appeal,
Yes.
when so. Direct the year to forward the records of the year. Now, what has happened? There's one to take effective for this one. Have the, has it been disposed of?
What's it?
Appeal?
Appeal lordship, it may be disposed of lordship.
They have not communicated.
No,
me,
no,
lordship.
regarding appeal lordship, I have no instruction regarding the position of this appeal lordship.
Get your
Two
instruction.
days lordship, I will, after 2 days lordship, I will.
This is the matter on 27/7/2026, on which date Mr. J.K. Goswami shall apprise this court as to whether the order dated 8/6/2026 have been complied with by the respondent number 3.
Deeply obliged.
I have specifically directed for disposal.
Lordship.
What is this?
Last occasion, Lordship, the Honorable Court directed me to obtain instruction whether my lord show cause notice was issued prior to cancellation of the work order, my lord. I have received the instruction, my lord. It is stated that no show cause notice was issued.
What is the matter about?
So work order was cancelled, my lord.
After receiving the work order on demand for construction of the RCC building, the site was not handed over and therefore the part of the building.
Page 41 is the my lord cancellation order.
Yes, what is your instruction?
My lord, no so cause notice was issued, my lord, prior to cancellation, my lord. Lordship may be pleased to produce the instruction.
Now what to do?
Lordship, our case is that he didn't know, my lord, that the reason behind that, but this is honorable court, since honorable court directed to obtain instruction, my lord.
Okay, now
It's
the
not
question is, the
notice
work
not
has
made
been.
prior to granting, but
Hare
really
Krishna,
the
when was it cancelled?
cancellation order is by page 41, it was cancelled 4th of August 25, my lord.
Or you are requested to produce before the honorable court that on the aforementioned that the work order was cancelled. You mentioned that the minutes of the meeting in connection with the disposal. Commissioner. Why you are saying that show cause notice has not been issued?
My lord, that they have
You were granted a contract. Now the contract was thereupon cancelled.
Cancelled.
Without, you were issued a work order.
Yes, yes.
Then
The site was not handed over to us.
site was not available to us. Okay. Scope has changed. Within the register of Suwan. When was it cancelled?
On 4/8/25. 4/8/25.
yes,
Work order was issued in 2020. And the period of completion was?
Period of completion of 3 years, no?
Huh?
3 years.
So at the time when they have given you
you didn't
till 2025, they have not provided you the site.
Yes. Because the site was occupied by one gas agency.
Understood. So therefore, how can you carry out the contract at the same rate? My question is that.
They have changed the rate. Earlier it was 3 crores 71 lakhs and subsequently 4 crores 93 lakhs.
When?
It is
you have a- What is that, man?
Where is it 4 crores?
The my lord, page 6 of my affidavit also lordship will find it, page 49, my lord.
Approximate value of the work was 3 crores 66 lakhs. Period of completion is 18 months
yes.
from the date of handing over the site.
Yes,
The site was not handed over.
not.
Now what happened thereafter?
Therefore, that site was occupied by one.
Was
gas-
it increased that? Price has been increased.
Yes, increased.
Huh?
Increased, my lord,
When?
in this subsequent order.
When?
It is,
You were issued a work order.
yes, work order was issued.
The issuance of the work order here, the site for construction could not be handed over due to non-clearance of the site. After revised proposal has been prepared as per demand and on the basis of the daily after the finance committee of the meeting and this redoing of the proposal as per is under process expected is happening in 2025. With reference to the above, no, it is the only the executive engineer who has said has not been increased. Estimate has been submitted. With reference to, I have the honor to return herewith the estimate for the aforementioned work duly countersigned by the undersigned for administrative purpose. For the purpose of further, the vetting according so and so, so and so. Thereupon they have taken the decision
They have
not to
cancelled.
proceed with it.
Yes, yes, madam.
This
cancelled.
happened in 2023. Today we are in 2026. You may have a case for damages, then it is a case of before the civil court, a breach of contract. But we cannot solve anything to the. It will be a case of Mr. Sharma, it will be a pure case of breach of contract. Go before a civil court claiming damage. Because you see, if they don't want to do the work now as per that, we are supposed to complete the work in 18 months. 18 months finished in the year 2021 itself. Or 22. We are in 2026. There was an enhanced estimate initially which was 3.66 crores. Enhanced estimate has been given by the executive engineer on at 4.93. This was not agreed to. So therefore, now they say that the design will change and everything will change. The scope of the work has changed. Yes, you may have used it, you may have done anything. This is a case of pure breach of contract. You can't help it.
But it is not.
Because can this court now direct them? Okay, don't do it. Now they have to give it to you to carry out the said work at the same rate. Yes, if you do it at 366, you leave it.
My lord, only, we have already, my lord, stated.
You are also not going to do at 366.
This is.
It is impossible for you to do the rate which you have quoted in 2020. We are in 2026. Impossible. It's a pure case for damages then. Breach of contract. You have been issued a work order. Obviously, the contract has come into existence. Now they have terminated. It's a case of damages. By way of a writ, I can't issue it, they'll grant you damages. You cannot do the same work now.
No, I can do the same work now at the enhanced rate.
No, obviously, they have not handed over the site to you. The 18 months will start from the date of handing over the site. Do you understand the stipulation? Meaning thereby which you have agreed is if they hand over the site to you today, 18 months will start. And the effect is you may have to do the work then if you based on the contract. Want to do it, do it.
My lord, because the change of design and structure, all, my lord, because it was up to 2020, now it's 26, my lord, 2026. So that's why, my lord, they have been cancelled because of the
Very
reasons
difficult,
which
Mr.
they-
Sharma.
My lord,
Get your instruction as to whether you'll withdraw tomorrow, 2 p.m.
no, tomorrow it is not.
Phone. You need to call up. You don't need to have anything. Call up and finish it off.
My lord, tomorrow I have.
Or I dismiss it. Whichever you want.
No, my lord.
Withdraw or dismiss with liberty.
On Tuesday.
Not Tuesday. This is not. Oh, okay, Monday. No, this is not a matter of that magnitude. This is 2 minutes business. Shouldn't have come on Thursday. You don't have urgency, na?
don't have so urgency.
No
Because we
urgency.
have deposited the
Malad,
security.
We do one thing, ask them to file an affidavit. Miss Udas, the learned additional senior government advocate, pursuant to the directions passed by this court on 23/6/2026, have placed before this court certain instructions. It is the opinion of this court that these instructions be brought on record by filing an affidavit. This is the matter upon such affidavit being filed. There is no interim order.
Malad.
No.
Yeah.
Yes, what it is?
Lordship, the petitioner's grievance is that he has filed a divorce petition, Lordship, in family court, which was not accepted, Lordship.
Refusal of the respondent accepting application.
Neither heard, Lordship.
On behalf of the
Lordship, the petitioner is a Muslim male, and in Muslim personal law, there is no provision to file divorce. So, Lordship, he has filed divorce in the Family Courts Act, Section 7(1)(d), Lordship. There is jurisdiction that family court can hear.
But Mr. Counsel, there is a big problem. Some court have struck off respondent number 2.
Lordship. We made respondent number 2 as court, but court denied that court cannot make a respondent, so family court is strike out.
Should have been the secretary to the or the register or something, chief executive officer, family court should have been made a party.
Lordship, after
Whom,
that, we
whom
have
should we
amended
direct for taking up the matter?
through the registry, Lordship, or direct, Lordship can
We
direct.
can't allow we can't ask the state, the judicial department to look into it. Because if you look into the judicial department will be interfering with the independence of the judiciary.
Lordship can direct us to file there, Lordship, we will file.
No, it is our mistake. We do one thing, we make you have the register, no? You have a register? What do they have, Mr. Das? What do they have, the family court?
Superintendent, I think.
Huh?
It's superintendent.
We implead the family court represented by the superintendent because it is the office who have not received. Court should not have rejected this. This court have heard the learned counsel appearing on behalf of the petitioner. And taking into account the grievance of the petitioner, no effective relief can be granted to the petitioner unless the superintendent of the family court, Kamrup Metro at Gauhati, is made a party to the instant proceedings. Accordingly, this court impledes the superintendent, family court, Kamrup Metro, which one? There's only one family court.
Only one, Lordship.
How many family courts are there?
One family court, there are 3 family courts.
Oh, it's okay. Of the superintendent is of the principal, there's a
Principal Judge Family Court 1.
of the principal judge family court number 1, Kamrup Metro at Gauhati, as the respondent number 2 to the instant proceedings. Mr. So-and-so accepts notice on behalf of the respondent number 2. Extra copy of the writ petition be served upon him.
NK Sharma.
So-and-so. By tomorrow.
Lordship.
Pusto. Mr. H.K. Das, the learned senior counsel who represents the respondent number 2, shall apprise this court as to why the petitioner's application for dissolution of the marriage have not been accepted. List this matter again on 28/2026.
Fine.
The counsel appearing on behalf of the petitioner further is directed to file a fresh memo of parties before the registry of this court within 3 days, and the registry shall, on the basis thereof, make necessary correction in the cause title and update the same in the CIS. File that. If you don't file it,
I'll file it.
God
Lordship.
won't help you.
Well, my
God bless.
name may be reflected or my
Name of Mr. H.K. Das, standing counsel of the Gauhati High Court, be reflected in the cause list.
Lordship, Lordship, there is a already February court submitted letter, Lordship. Then when we
Understood, madam, but the court by an order struck off.
Sure.
I know that. That is why, didn't I say that that was a mistake committed? And that is why I will not ask you to file the petition, because it is our mistake. Don't you think? Yes, United Drilling Tools. What must
Please, your lordship. My senior, she was here, but
Who?
G Goswami. She started feeling a little under the weather, and so she left just now.
Okay, very well.
Can this matter be listed for some other date, your lordship?
There's no urgency.
There is actually. This is a matter that pertains to blacklisting, your lordship.
You sure?
Yes, yes, your lordship.
Blacklisting?
Yes, lordship, yes.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner expresses urgency in the matter for which the matter stands adjourned to be listed on August 2026 at 2 p.m. for final disposal.
Oblige, your lordship.
Why are you writing, Mr. B. Gogoi? What is that? If you appear as an additional advocate general, I would not grant you anything.
The issue regarding
Of?
grade 4 employee was discontinued in 2016.
Why the matter has come up before me?
He was the employee of a court, district court.
Does he want the regularization?
But there was a policy in 2015.
Oh, yes, I
Yes,
remember.
That was one
He
time
was left
actually.
out.
That was one time policy.
Ah,
2015.
your specific case is that ended immediately after 2008 or something, isn't it?
Yes, 2015 policy, one time, then he got discontinued
In 16.
in 16.
Hmm.
And by now, perhaps going by the details, he will be around 50 years of age.
But is she working?
No, no,
No.
2016 discontinued.
Across the honorable court directed that his case for declaration should be considered. That was turned down, rejected.
But it was 46 in the year 2023. She will be now 3 years down the line, 49. Okay. Anyways, so we do one thing, have it on next Tuesday? Next Wednesday, Friday, Thursday?
Thursday. Can be taken.
Next Thursday, yeah, 30. Take it up on Thursday. Without him, presence of here at 5:15, it doesn't look.
Yes.
List this matter on 30. Due to paucity of time, the writ petition could not be taken up, for which the matter stands adjourned. Be listed on 30/7/2026. Huh?
Yes, ma'am.
Okay, I will say. Read it. Again, same.
This is overqualification, my lord.
Huh?
Overqualification.
Okay, we have it on 30. There, Mr. A. Samoa is appearing for the other side.
Yes.
Who has the overqualification? No. Who is the petitioner?
Yes.
Counsel. Petitioner counsel have not been appearing. Y and Mohanto.
P. Mohanto.
P. Mohanto means?
P. Mohanto.
Pritam Mohanty.
Is overqualified.
No,
Respondent
respondent overqualified. Petitioner prayed for his cancellation.
Respondent cancellation.
Okay. I passed many orders on this line. huh?
Yes, yes.
Due to paucity of time, the matter could not be taken up, for which the matter is directed to be listed on 30 so and so. 37, huh?
The interesting case is that the district judiciary, went ahead with a departmental proceeding in this matter, whether he has got qualification or not. And departmental proceeding inquiry officer came to a conclusion that no, his qualification is all right. But there are materials that he was overqualified. For this reason, that reason, the headmaster was not produced, or he could not give correct evidence on those perversity and all. The charges was held to be not proved.
The charges have not been, you have initiated departmental proceedings and charges not proved. Then how can this court, unless that is challenged? Anyways,
Also will take, there is something into it, my lord. I am also finding it difficult to conceive the inquiry report, my lord. Deeply obliged.